The House will come to order. Today, the Pledge of Allegiance will be led by Representative DeGraff, House District 22.
Please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Schiebel, please call the roll.
Representatives Amabile, Armagost, Bacon, Representative Bacon,
Excused.
Byrd, Bockenfeld, Basenecker, Bottoms, Bradfield, Bradley, Brown. Brown is here. Catlin. Good morning. Doherty. DeGraff. Degree Kennedy. Representative Degree Kennedy.
Excused.
Dixon. Duran. English. Epps. Evans. Frizzell. Froelich. Garcia. Representative Garcia.
Excused.
Gonzalez Gutierrez. Rep. Gonzalez Gutierrez.
Excused.
Hamrick. Hartsook. Herod. Representative Herod.
Excused.
Holtorf. Judah. Joseph. Kip. Leader. Lindsay. Linstead. Luck, Lukens, Lynch, Mabry, Marshall, Martinez, Morrow,
Here.
McCormick, McLaughlin, Michelson Janae, Ortiz, Parenti, Representative Parenti,
Excused.
Puglisi, Ricks, Representative Ricks. Ricks is excused. Sharbini. Sharbini's excused. Sirota. Snyder. Soper. Story. Taggart. Titone. Valdez A. Velasco. Vigil. Weinberg. Weissman. Wilford. Wilson. Winter. Woodrow. Young. And Madam Speaker.
Here. With 61 present, 4 excused, we do have a quorum. Representative Joseph, good morning.
Good morning, Madam Speaker. It is an honor to serve with you.
And an honor to serve with you.
Members, I don't have anything clever to say this morning as to why the journal should be approved. You've heard a lot of exciting, different reasons why the journal should be approved. I'll say today, on behalf of the children from all around the world, please vote yes to approve the journal. I move that the journal of Thursday, April 6, 2023 be approved as corrected by the Chief Clerk.
Members, you have heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. Aye. All those opposed, no. The motion is adopted. Announcements and introductions. Representative Michelson Janae.
Thank you, Madam Speaker. I have been excused by the Majority Leader Wednesday afternoon and Thursday.
So approved. Representative McCormick.
Thank you, Madam Speaker. I wanted to announce today there will not be an Agriculture, Water, and Natural Resources Committee meeting today, but something exciting is happening on Wednesday. We have a Water Education Colorado Water 101 seminar for all those interested, which will be in the morning at 7:30 to 8:45 Wednesday in House Committee Room 112. We will be learning about municipal water efficiency, growth, and affordability. So I hope those of you that don't have anything else to do on Wednesday morning, or even if you do, this is really important and exciting. So WECO Colorado, Water Education Colorado, on Wednesday, 7:30 in the basement.
Thank you. Representative McLaughlin.
Thank you, Madam Speaker. Good morning. Good morning, House Education Committee. We have 4 bills coming up today. We are not going to be listening to 1239 today, but we will be hearing 99, 1262, 1263, and 1261. We'll see you there. Thanks.
Thank you. Representative Woodrow.
Thank you, Madam Speaker. Members, the House State Civic, Military, and Veterans Affairs Committee will be meeting 1:30 p.m. LSBA to hear House Bill 1259, Senate Bill 53, and House Bill 1270. See you then.
Thank you. Representative Froelich.
Thank you, Madam Speaker. The Transportation, Housing, and Local Government will meet Tuesday afternoon and Wednesday afternoon. LSBA, 1:30, we hope. If it's a little bit later, then join us when you can.
Representative Bradfield.
Thank you, Madam Speaker. I am down here today on a bright, beautiful Monday morning to let everyone know that Tuesday at 7:15, The legislator Bible study will be held in 0109 downstairs. Time, once again, 7:15. Hope to see you there.
Thank you. Representative Michelson-Janae.
Thank you, Madam Speaker. Members of the Public and Behavioral Health and Human Services Committee, pay attention. This is important. Tomorrow, when we meet, I need you to not be wearing high heels. Not be wearing high heels. So if you're wearing high heels, bring a change of shoes for committee. That's all I'm saying.
So intriguing. Representative Snyder.
Thank you, Madam Speaker. House Finance at 1:30 today. House Bill 1279 will be laid over till Thursday upon adjournment. Everything else on the calendar is good to go. Thank you.
Thank you. Minority Leader Lynch.
Thank you, Madam Speaker. Quick announcement for those of you that don't get your fix of McDonald's. Tomorrow, McDonald's will be served outside the old Supreme Court, some breakfast starting at 8:40 tomorrow.
Thank you. Representative Weissman. We have a tribute, members.
Yes, thank you, Madam Speaker. I would like to ask Mr. Schiebel to read the tribute.
Mr. Schiebel, please read our tribute.
The House of Representatives convened in the 74th General Assembly hereby recognizes the 25th anniversary of the Good Friday Accords. On the 17th of March, during the annual celebration of the Feast of St. Patrick, the patron saint of Ireland, Irish Americans join with men, women, and children of all ethnic origins and for one day become Irish and celebrate St. Patrick. In addition, this year marks the 25th anniversary of the Good Friday Peace Agreement. The Good Friday Peace Agreement has been a considerable success. There are people alive on the island of Ireland today because of the continuous bipartisan support for the Good Friday Agreement over the last 25 years of state legislators, U.S. presidents, and United States Senate and House of Representatives, and elected officials working in partnership with the government of the United Kingdom and the government of Ireland. The Good Friday Agreement represented a landmark breakthrough that provided Ireland with a political framework to address its future, acknowledged the right of differing political traditions to pursue their goals of remaining part of the United Kingdom or of Irish unity, and demonstrated democratic and peaceful means of resolving differences. The Colorado House of Representatives recognizes the Good Friday Peace Agreement on this year of the 25th anniversary of its ratification as the framework for lasting peace in Northern Ireland and extends commendations to the British and Irish governments for their ongoing support and implementation of the Good Friday Agreement. On request of Representative Mike Weissman, given this 10th day of April 2023, State Capitol, Denver.
Representative Weissman.
Thank you, Mr. Schiebel, and thank you, Madam Speaker. So members, today to the day, April 10, is 25 years since the Good Friday Accords were announced after many, many years of negotiations in which the U.S. played a significant part. Former U.S. Senator George Mitchell was a special envoy and helped bring this about. If you are somebody who has Irish ancestry, as I do, and who leans into that ancestry, this was a pretty big deal. I was going to college in the Boston area at the time. This was also a bigger than usual deal in the Boston area because there are so many folks of Irish ancestry, including in local politics there. And you know, if I remember right, this ran on the front page of the Boston Globe, which is the local paper. It's one of those things where I still remember where I was standing and what the weather was like that day when I heard the news, because it was that big in terms of bringing peace to Ireland. So it stands as an example of what our nation can do when we lend our weight on the global stage to try to negotiate things. It stands as an example of two sides of a dispute who really were dug in some cases with the most severe consequences for decades to try to turn a corner and find a new path forward. You know, I went to Ireland for the first time in 2006, which wasn't so many years after this happened. At that time, you would cross from the Republic into Northern Ireland. It was just like driving down any road. You could walk down the main street of Derry, you know, sort of the prime city in the north, and it was just a beautiful, bustling place to be. A friend of mine had shared a prior trip. She went when she was younger, circa 1990. Not so many years prior to the Accords. At that point, when you would cross from the Republic into Northern Ireland, you would be stopped, and they would squeeze the toothpaste out of your toothpaste tube to make sure it wasn't Semtex. That's how bad it was not so many years before the Accords. So I appreciate everyone taking just a few minutes to hear about this today. I've referred in the past to the American Irish State Legislators Caucus. This is a bipartisan effort that is facilitated actually by the National Senate of the Republic of Ireland, and remembrances like this are happening in state capitals across the country today, again, out of recognition that we have had in this country of both facilitating this peace and standing in support of it after the fact. So thank you.
Thank you. Members, we have a bit of business. Mr. Schiebel, reports of committees of reference.
Committee on Appropriations. After consideration on the merits, the committee recommends the following: House Bills 1060 as amended, 1075 as amended, 1102 as amended, 1105 as amended, 1120 as amended, 1153 as amended, 1161 as amended, 1178 as amended, 1213 as amended, 1231 as amended, 1237 as amended, 1246 as amended, and Senate Bills 182 and 250 be referred to the Committee of the Whole with favorable recommendation. Committee on Education. After consideration on the merits, the committee recommends the following: House Bill 1109 be postponed indefinitely. Senate Bills 4 as amended and 70 be referred to the Committee of the Whole with favorable recommendation, and Senate Bill 61 be referred to the Committee on Appropriations with favorable recommendation. Committee on Energy and Environment. After consideration on the merits, the committee recommends the following: House Bill 1272 be amended as followed, and as so amended be referred to the Committee on Finance with favorable recommendation. Committee on Finance. After consideration on the merits, the committee recommends the following: Senate Bill 49 be referred favorably to the Committee on Appropriations.
Madam Majority Leader.
Thank you, Madam Speaker. I move that the following bills be made special orders at 10:17 a.m. House Bill 1251, 1026, 1032, 1056, 1216, 1264, 1227, 1229, 1184, 1233, 1235, 1236, 1243, 1234, 1245, 1217, 1060, 1075, 1102, 1105, 1120, 1153, 1161, 1178, 1213, 1231, 1237, 1246. Senate Bills 182, 8, 60, 74, 154, 93, 144, 85, and 162.
Representative Luck.
Thank you, Madam Speaker. I would like to object to this list of special orders, seeing as more than 10 of them were not on the general orders calendar and we did not have notice. Thank you.
The House will stand in a brief recess. The House will come back to order. Members, pursuant to House Rule 6E, our special orders calendar is in compliance with rule. It is customary and practice based on our past history that bills that are passed in appropriations often do find themselves up for second debate the same day that they are moved through appropriations. So with that, the objection is denied. Members, we will proceed with second readings, and we will now resolve ourselves into the Committee of the Whole for consideration of special orders. Representative Gonzalez Gutierrez. Yay, thank you. The House will now resolve itself into the Committee of the Whole for consideration of special orders. Representative Gonzalez Gutierrez will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen and on your iPads. Bills will be laid over upon motion of the majority leader, and the coat rule is relaxed. Mr. Schiebel, please read the title of House Bill 1251.
House Bill 1251 by Representatives Epps and Puglisi, also Senator Pelton B., concerning the repeal of obsolete provisions in Title 39 of the Colorado Revised Statutes.
The committee will stand in a very brief recess. The committee will come back to order. Madam Majority Leader.
Thank you, Madam Chair. I'd like to proceed out of order for the consideration of House Bill 1026.
Seeing no objection, the committee will proceed out of order for consideration of House Bill 1026. Mr. Schiebel, please read the title of House Bill 1026.
House Bill 1026 by Representative English, also Senator Fields, concerning family time for grandparents.
Representative English.
Thank you, Madam Chair. I move House Bill 1026 and the Judiciary Committee report, and I have an amendment.
Thank you, Representative English. Is that amendment to your committee report?
Yes.
Okay, to the committee report.
I move L007 and ask that it is displayed.
Just one moment. Okay. Amendment L7 is before us. Please proceed, Representative English.
Thank you, Madam Chair. This is language that strikes what the court is already doing, so it's redundant, and I ask for an aye vote.
Any further discussion on Amendment L7? Seeing none, the question before us is the adoption of Amendment L7 to the Judiciary Committee report. All those in favor say aye. All those opposed, no. The amendment is adopted. To the committee report, Representative English.
Thank you, Madam Chair. House Bill 1026 is family time for grandparents, and what this bill will essentially do is ensure that grandparents can have family time with their grandkids in the case of a divorce or parental allocations have been set up through the court process. And in the bill, it states that only the people that are on the actual order can have the grandchildren. So the safety of the kids is first and foremost. And there are lots of grandparents across the state of Colorado that has ran into issues with this, and this is where this bill has come from. So inclusivity is very important when it comes to grandparents, and I would just ask for an aye vote.
Any further discussion on the committee report? Representative Luck.
Thank you, Madam Chair. And I thank my colleague for bringing this bill. I too agree that grandparents are integral to healthy families and healthy kids. During the committee, I brought up a question about the statement that is made a couple of times in this bill to define grandparent. I'm just looking for it really quickly here to sorry, my apologies. It speaks, I have a different version in my hand than the amendment that I have references, so I apologize. But basically, there is a discussion in here about a grandparent being related to a child by half or whole blood relation, which was a confusing question to me, and I asked it in committee, and I was told that this is just archaic language. It's been in the family law statute for a very long time, and that the definition was just pulled over for consistency's sake. All seemed reasonable, but it continued to bother me. How can a grandparent be related to a grandchild in whole or half blood, right? How can a grandparent be half related to a grandchild? What does that actually mean? We understand half siblings, right, where you have a parent, you have a shared parent, but you don't have two shared parents. That makes sense. But how can a person whose progeny exists because of them only be in existence by half? Does anybody else follow me? It just seems a little bit confusing how that could be. This language, like I said, is borrowed from current law, CRS 19-103-70A, but that doesn't just mean that we should adopt it whole cloth without giving further consideration. Given the rise of blended families, many people are related to others by half, right? But again, how does one have a half child or a half grandchild? So doing some research, I discovered that there is actually a real concern here because there is some historical evidence to suggest that this was grounded in racism and in just an era that we here don't want to acknowledge as valid. And so, not that anyone by this language today is suggesting it, I still think that we should be purposeful with our definition. I still think that we should make sure that there is no confusion around this, that there is no hearkening back to those kinds of quantum blood kind of language and terms. And so basically, I have an amendment that I would like to put forth. The amendment is L008, and I move it and ask that it be displayed.
Thank you, Representative Luck. Members, if you need to have very important conversations, I'm going to ask that you please take them to the sides, as in outside of the chamber. And Representative Luck, can you please can you move the amendment? I know you kind of said it, but I just need you to say it.
Yes, absolutely. Thank you, Madam Chair. I move Amendment L008.
Thank you, Representative Luck. Please, the amendment is before us. Please proceed.
Thank you. So all this does is strike that questionable language and just substitute it for blood. So getting rid of in whole or in half and just allowing for it to be blood. Some of those other considerations related to marriage and adoption and what have you are already covered, but this just ensures that we are honoring the full relationship between those who had a blood child, a blood grandchild, and I ask for an aye vote.
Any further discussion on Amendment L8? Representative English.
Thank you, Madam Chair. I ask for a no vote on this amendment.
Any further discussion? Seeing Representative Luck.
Thank you, Madam Chair. Again, I just do think that it's a clarifying point that is getting rid of some language in this that could cause confusion and that could harken back to a time that otherwise we would not want to codify again. Thank you.
Any further discussion on Amendment L8? Seeing none, the question before us is the adoption of Amendment L8. All those in favor say aye. Aye. All those opposed, no. No. Amendment L8 fails. To the committee report. Seeing no further discussion, the question before us is the adoption of the committee report. All those in favor, please say aye. Aye. All those opposed, no. The committee report is adopted. To the bill, any further discussion on House Bill 1026? Representative Holtorf. Representative Holtorf.
Thank you, Madam Chair, and thank you to our Chief Clerk for clarifying some things with respect to the committee report and the strike below. As I understand, this is now the body, which is the amendment of the bill, which I'm looking at here, which is a 7-page bill. I believe we heard in committee. And I just want to make sure that everybody understands, and I have a question for the bill sponsors as well, because it appears to be a significant change here. I'm not sure how the strike below affects the bill, but one of the considerations I had is for grandparents of children, biological grandparents of children that have been put into foster care or have other custodial care provisions, kin care or foster care provisions. Does this bill, as now it's presented with the strike below, does it allow for those grandparents to have the opportunity and to have that grandparent time? I had a situation in my district, constituent affairs, that was dealt exactly with this issue. And I need to know if this bill actually addresses that, if I'm going to get behind it or if additional changes need to be met. And I'm going to explain myself here, Madam Chair, with respect to now what we're looking at in House Bill 1026. In this particular case, the mother was incarcerated for drug use, drug abuse, and allegedly distribution of drugs. The grandmother requested custody, but that was not availed, and the daughter, and the granddaughter rather, in this case, was sent into the foster care system. Now, unfortunately, this particular situation has a very bad ending, but I want to make sure that grandparents in this particular case, and I'll explain a little bit further, have the ability to have the time to see these grandkids. And does this do this? Because in this particular case, the foster care was assigned to a family that had multiple foster care children, in excess of 5 or 6. I believe the number was 6. Now, in these families, it's very concerning when anybody takes in too many kids because it's hard to take care of the kids. If anybody's been a parent, you know that it can get pretty confusing when you have more than 2 or 3 or 4 children under your care, let alone 5 or 6. But in this particular case, this young child, the grandmother couldn't have any interaction in this particular case with the granddaughter. And ironically, it was assigned out of state, which I never could understand. How that out of state, now the daughter was incarcerated out of state, and that may be why. The custody was assigned out of state. This grandmother was unable to interact with her granddaughter, and over a less than 2-year period, the granddaughter choked on a plastic toy and died in the care of the foster care family. The question that my constituent asked me repeatedly as we went through this whole process, and this was a near 2-year process. Now, being completely transparent, the grandmother did have, about 15 or 20 years prior, also had some felony charges that she had to deal with. But those were long past. I believe that is why she was not granted custody by Human Services and the courts in that case, perhaps. But the real question I have here for the bill sponsors is, how does this bill, House Bill 231026, address family time for grandparents in some of these very unique situations? Or does it fall into this particular case? Because grandparents do want to have time with their grandchildren, even if they're in an alternate placement condition. So that's the question to the bill sponsor, and I'm going to talk a little bit more because I think she's going to formulate a good response. I can see her writing feverishly, and I'm pretty sure that's because she's got some good ideas about this situation. But this is really important, and I'm going to tell you, when grandparents, even when grandparents are watching the care and custody of children with their own children. So that's the question I have with respect to this House bill concerning family time for grandparents, Madam Chair, and specifically with the strike below. I haven't had a chance. You know, there was objection made earlier because oftentimes it's really hard to digest all these bills, particularly with the amendments over a 24-hour period, but specifically with a high volume of bills. So I'll turn this back over to the bill sponsor and see if there's any consideration for this, as that particular case I still live with that outcome as a state representative in House District 64, my former House district, specifically in Bent County, if you know where Bent County is. Thank you.
Representative English.
Thank you, Madam Chair. I would just like to say we moved from one title to another, which is why we have a complete strike below, and there was very robust stakeholding. And this does not supersede anything the court orders. And this bill, to answer your question, Representative Holtorf, it's a pathway for the judge to order visitation with grandparents when ruling on the best interest of the child. A diversity of experience is important for the overall well-being of children by being able to engage with both sides of the family. And this is what this bill does. And I ask for an aye vote.
Representative Holtorf.
Thank you, Madam Chair, and thank you to the bill sponsor for that answer. Because that's what I think we want. That's what grandparents want, being a grandparent for 2 grandkids. We do want that opportunity, and it looks like this particular bill, with the strike below now, is going to offer that. I do have a caution for the chamber, as I've sat on public health now 4 years. Oftentimes, human services and the courts impart some bias, as I've been watching this, against kinship and kinship placement. No, I know. Thank you. Thank you to the chairwoman from Public Health, and thank you for that. And I do understand that's not this bill, but oftentimes what happens when the immediate family or biological family is not in that chain of custody for the care, then indirectly the grandparents get marginalized, if that may be the right word. And I believe that may be why we're doing this. I don't know. I hope that the grandparents aren't, and I'll say it this way, and it may not be a good way to say it, but this is the way I'm going to say it, Madam Chair. Oftentimes the mistakes of somebody's kids shouldn't be, that the grandparents shouldn't be punished for the mistakes of those kids that are raising their kids. And that happens. That's a real thing. And I think it's indirect. It happens indirectly. In the case that I explained out of Bent County, it happens indirectly. And sometimes those are heartbreaking stories. Literally heartbreaking stories. And I could tell more, but I'm not going to. We got a lot of business to do today. I could tell a few more stories about this, but I'm not going to, Madam Chair, because I think this is going to get me pointed in the right direction with that response. So thank you for that to the bill sponsor.
Assistant Minority Leader Puglisi.
Thank you, Madam Chair. I'm really grateful for this bill. When I was a county commissioner, I oversaw human services for my county, but then also represented child welfare at a statewide level and represented a lot of counties on the Western Slope. And I will say one of the issues that was consistently brought up to me from families was the ability of grandparents to interact with their grandchildren and how difficult it was. And then you see these children who don't have anybody. And really could be surrounded with love, and there's nobody out there, and we try to find and place them, and this isn't a kinship bill, but hearing those stories about not having any family supports, when we do have more family supports out there for some children, being able to strengthen those ties, I think, is really important. And even for myself, I was thinking about this the other day. I was thinking about your bill, actually, as I was driving to work the other day. It had snowed. The roads were really icy coming out of Colorado Springs. And someone almost hit me, and I was like, oh my gosh, I always think about what happens to my children if something were to happen to me. And I can tell you that I know for a fact if something were to happen to me, that my kids would not have access to their grandparents. And I think that's really hard because they are incredibly close to my family. And so a bill like this ensures that my family would have an opportunity and a voice to say, hey, wait a second, we want to continue to be part of this family. And that's really important for me. So I really appreciate this bill being brought forward. I know there were a couple of questions, which I think are good questions to get the answers to, but I think this is a good bill, and I think there are a lot of kids in Colorado who will benefit greatly from this bill. So thank you.
Any further discussion on House Bill 1026? Representative Frizzell.
Thank you, Madam Chair. I rise in support of this bill. I am myself a grandmother of two beautiful little girls, and I've always, you're just always concerned about the kids and making sure that they're okay. I have a constituent who contacted me earlier in the session with a terrible, terrible, tragic story. And she's going through just what this bill is intended to do. And her tale was so tragic. She lost her daughter, and her daughter has two kids. And the kid's father has custody of these two little ones, and she has no access to them. And she's having to fight through the court system just to be able to see them. And she's so concerned because apparently the dad isn't that great. He's not all that. And being really difficult and obstructive. And she needs this bill. She needs this bill. It is important for kids to know that they are loved and that they have family around them who supports them in really difficult times. So I would really like to thank the bill sponsors for bringing this bill and making sure that our little kids are all safe and loved. So thank you.
Representative Bradley.
Thank you, Madam Chair. I come down and rise of support for this bill as well, and thankful to the bill sponsors for bringing it forward. My stepbrother, I've told you all, has struggled with addiction many, many times, many stories of addiction, and his wife blamed us for his addiction, and out of her anger for his addiction, took their three boys away from all of us. So it was 3 years that I did not get to see my nephews. She held that over our head. My dad is the stepdad to my stepbrother and was more of a father than his dad ever was, more of a grandfather, probably more of a grandfather than my brother, a father figure than my brother ever was. So those three boys, grandparent rights are being stripped all across the country. In Tennessee, there's not a lot of laws allowing for grandparent rights, and they were going to go through a costly battle and court costs and everything just to be able to see my three nephews. So I really love this bill. I think grandparents provide a lot of love and need for grandchildren that they don't get sometimes from their parents. I see it in my own kids with my mom. So I just wanted to thank the bill sponsors for bringing this forward, and I am in support. Thank you.
Representative Bottoms.
Thank you, Madam Chair. I am going to give you a bunch of reasons why to vote for this, and if you're on the fence, I might convince you to vote for this, but I'm actually going to vote against it, and I'll explain why. I've done this for years. I've been a go-between or arbitrator between families at every single level. Doesn't matter. Grandparents also included within that, because people think pastors do everything. And so I've been asked to do these things where I've sat with families and tried to get parents, grandparents, aunts and uncles, everybody to let there be, just see the kids. I mean, it seems like a simple thing, right? See the kids. And I'm also very strong, very pro family needs to have access to the kids. I'm very strong about that. I also have 2 grandkids, and I have thought about this, and I've actually thought about this bill as much as any other bill and processed this and talked to people about this. What do you think? How would this work, or how would this work? And so I do want to throw this out here because I've experienced this a few times. Our state law actually allows a judge to give grandparents ability to see their kids, their grandkids. We already have that in state law. What this bill does is it expands that a little bit. And I think also adds some different funding for attorneys involved in the process. And I'm not necessarily against that either. So here's the reason that I'm against it, is while I do believe all that stuff, and I do believe that grandparents, I can't imagine my son telling me I can't see my grandkids. That would gut me. And I think anybody that has grandkids understands that. But I don't necessarily think, since the state already gives that ability, I don't think this is where the state needs to be enhanced or even kind of engrossed in this. I think the state needs to stay out of these things because the state doesn't understand the big picture in the family dynamics. And having sat in many dozens and dozens and dozens of these moments, it's difficult for somebody like me that knows the family to really understand all the process. And this is always my philosophy. If you want to do what's best for the child, keep the state out of it. The moment the state starts getting involved, it's going to get wrong and it's going to get messy. At the same time, again, I am torn on this because I understand every positive that's involved with it. I understand every bit of this, and I understand why the sponsor would bring it. I get this. I totally get it. I just don't think the state needs to be enlarged within this context, or really any context, but specifically within this context. So that's why, I may be the only one, but that's why I would have to be a no on this bill.
Any further discussion? Representative Hartsock.
Thank you, Madam Chair. A couple quick questions as I've gone through it for the sponsor. Appreciate everything coming forward, and I'm just curious, dealing with the military, we have some bases here when they go through divorces and things. I mean, of course, the military has to, everything is done in the state courts. But I've seen, because usually families are moving and different grandparents out of state, and it tends to get a convoluted mess. Were there any discussions or any impact, that's going to look at those military families and how that's going to affect the grandparents coming from an out-of-state to look at their kids here, or any of those issues that happen? And then the second thing that kind of pertains to having known folks that have been the court appointments to go in and be the advocates for the children, do we have, I didn't see it, but is there specifications for what they have to go in there with this bill for the grandparents now? Because you outline, normally that person's going in as a child advocate, has very details of what they're outlining for the child, their schools, their health care, to some of the parents. What happens if there's a conflict with what the grandparents are looking at? Is that addressed, or how are you doing that? So those are my 2 questions, please. Thank you.
Any further discussion on House Bill 1026? Representative Luck.
Thank you, Madam Chair. So going back to the definition of grandparent, just wanted to clarify my prior comments. It caused some confusion, I think, amongst at least some members. So the definition here, in terms of being able to have visitation rights, family time, defines both grandparent and great-grandparent basically as a person who's, well, let's just read it. Great-grandparent means a person who is the grandparent of a child's father or mother who is related to the child by blood, in whole or by half, adoption, or marriage. So you can be related to the child by blood, adoption, or marriage. Those 3 categories under this bill. except that the great-grandparent, and then under the definition for grandparent, the same is included, does not include the grandparent of a child's legal father or mother whose parental rights have been terminated in accordance with these sections in law. And so, as we talk about definitions and as we talk about grandparents, I just am wondering if maybe the bill sponsor can give me some dialogue around why those with the parental rights of their child being terminated, why that then precludes them from being able to pursue this time. Now, the reason I'm asking this is because I do think it's something we need to grapple with and we really need to wrestle with. Because on one hand, let's say you have a foster situation that leads to adoption. And so in that situation, the parents of that child, let's call him Joe, right? Joe's parents, biological parents, terminate their rights to Joe. And let's say Sally and Bob, they adopt Joe, right? And Sally and Bob, they now have this little one in their family, and they may have an interest to ensure that Joe's biological family is not in contact with Joe. There may be a situation wherein that is a healthy dynamic. There may also be many situations when Joe had maybe a poor relationship with his parents, maybe no relationship with his parents. I'm thinking of one little guy in my life whose parents were in and out of jail, and yet he lived with his grandmother before he got into the foster system and then was adopted. And so his relationship with his grandmother was much stronger than his relationship with his parents. In fact, he didn't even know his parents upon sight, right? He had to be told that is your biological father. That is your tummy mommy is kind of what he was told when he was very little. And so should, by law, by complete exclusion, no discretion to the court, but complete exclusion, we keep out those grandparents whose parents might have sought to terminate their rights, right? Like, does this make sense? I'm getting some looks that tell me this isn't making sense. So I guess what I'm just trying to grapple with is when we put it in statute, that is sort of the parameters that are set for the court. And so should it be just an outright ban in terms of those grandparents whose children terminated their parental rights from seeing their grandchildren? Should it be a complete ban, or should there be some discretion given to the courts so that the courts can look at every situation and decide whether Joe should be able to actually access his biological grandparents and have relationship with them and build community with them and have access to his ancestry and all sorts of other aspects of his story? Or should we as a state just completely prohibit that and say, nope, if your parents terminate the rights, then all of the rights that go upwards in that family line are also in that moment terminated, which, as I said, could actually have valuable place in law, especially when you're talking in an adoption context, because it can get really messy really quickly, especially if there are a lot of grandparents who are in the picture because there were divorces or deaths or remarriages and that sort of thing. But again, I do think that it's worth grappling with, and so to the extent that the bill sponsor would be so kind as to help me understand why the decision to just ban it outright as opposed to giving discretion to the court, that would be helpful. Thank you.
Representative Winter.
Thank you, Madam Chair. My questions kind of fall in line with Representative Luck. An issue with skipping over that family generation if you had a parent sign away their rights, whether it be through adoption or if it's just because the parent realizes that they're not doing a good job of parenting and are willing to do that for the benefit of the child. In the business that I am in as a funeral director, I see this dynamic play out a lot of times. And there are these special situations that I think Representative Luck's trying to get to with this to make sure everything's covered and everybody's covered in this situation. And if a parent, whether it be because of an addiction or another issue, we've seen parents give up rights for lots of a reason, like I said, for the benefit of the child. And to cut those grandparents out of that right seems fairly drastic. And if we're trying to keep the, the family line whole, and if we're trying to make sure that the heritage is passed along, and I think a lot of this has to do with family relations when it comes to talking about family history, heritage, where their family comes from. If we're trying to keep that lineage whole, I think to skip over those grandparents based upon, especially when you look at the adoption section of this, if somebody's trying to do what is best for the child based on the situation they're in and they choose life, I think that the grandparents shouldn't be cut out of this equation. So my questions fall. I came up right behind Representative Luck, but my questions fall right in line with hers. Why can't we make those accommodations? And why are we going to have the state totally cut them out? So the question would be passed along from Representative Luck to myself to the bill sponsor.
Any further discussion on House Bill 1026? Representative Hartsook.
Thanks, Madam Chair. Yeah, I was just following up. I didn't know if you had a chance for the two questions that I asked earlier about the military impacts and then the, as the advocate, going in there with the priorities of where that fell. Thank you.
Assistant Majority Leader Bacon.
And Representative, from Douglas County, if we got the question wrong, you might have to repeat the question, but would you mind repeating the question? Sorry.
Representative Hartsook.
Madam Chair, yes. Yes, so the first question was, in the military, because usually you're moving in from different states, what happens, there's a divorce, and grandparents say to live out of state or something that's going on, and there's a disagreement of how that custody is going to go. Do you have was that part of the discussion, or was anything fleshed out for how will that impact grandparents looking at out of state, the military? And then the second one was, in particular with the child advocate going in there with the priorities, how is that, I guess, delineated when they're looking at, because usually they're coming in to be the advocate for the child to the court, yet if that's in conflict with the parents or the grandparents, how has that adjudication process gone through?
Assistant Majority Leader Bacon.
Thank you. Apologies. So the court proceedings would typically be the same in the sense that grandparents have to file where the children are and where all of the agreements are around custody. If it's dissolution of marriage, the divorce settlement and whatnot. And so even though grandparents may live out of state, they file in the state to where the children are. And then when it comes to the whole purpose of having the GAL or the guardian ad litem is so that the child has an advocate that's in their best interest and not in the best interest of the parents or the grandparents. So that guardian is kind of like an attorney, but it's someone who advocates for the interest of the child, and that's why that person is there, to help sift through those interests, to help bolster that determination of what's in the best interest of the child.
Any further discussion? Representative Luck.
Thank you, Madam Chair, and I will also renew my question and see if there is a response from the bill sponsors as to why. So my question was, in the definitions, we are by statute excluding any grandparent or great-grandparent whose child terminated their parental rights. And not giving discretion to the court to look at it case by case to see maybe the mother terminated her parental rights because she. I'm thinking of a particular family, and the grandchild had a relationship with it's under the definition of grandparent and great grandparent there at the end after marriage semicolon except that. Blah, 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 on pages 2 and 3, I believe, of the committee report. But the idea being that if you have a situation wherein perhaps a child's biological mother terminates the rights, that child has a strong relationship with the biological maternal grandparent, why, without any discretion to the court, why would we just unilaterally sweep and say that particular grandparent should not be considered at all in these kinds of conversations, as opposed to giving the court the discretion to look case by case and determine whether they have enough. Well,
any further discussion on Assistant Majority Leader Bacon?
Okay. Oh, I'm already acknowledged. Sorry. I think you were looking at page 2 of the committee report. What I do understand about, right, in accordance with Title 19. Okay, sorry.
Assistant Majority Leader Bacon.
So part of the reason why this is a strike below was about where this should be placed between Title 14 and Title 19. Title 19, for those of you who may or may not know, is the space where custody is determined by the court. So Title 19 also includes everything from delinquency to neglect to termination of parental rights. And so within that space, if we're thinking about children in foster care, that is a whole different space from where we wanted this to live. Where in Title 14, we're just talking about child custody cases in the domestic relations sense. Our guess is that when we were talking about this bill, we did not actually want to interfere with the state and parental rights cases. We wanted to talk outside of that space. And so I think there are legal loaded presumptions when it comes to parental rights if they've been terminated by the court, and that since those cases are already heightened by way of best interest for the child, connections to grandparents may or may not touch that, and we didn't want it to live there. So again, we wanted this to stay in the domestic relations space where there are simple child custody cases and there aren't any questions that would trigger Title 19 when it comes to neglect, abuse, parental rights, and whatnot.
Further discussion on House Bill 1026. Seeing none, the question before us is the passage of House Bill 1026. All those in favor say aye. Aye. All those opposed, no. House Bill 1026 passes. Mr. Schiebel, please read the title of House Bill 1251.
House Bill 1251 by Representatives Epps and Puglisi, also Senator Pelton B., concerning the repeal of obsolete provisions in Title 39 of the Colorado Revised Statutes.
Representative Epps.
Thank you, Madam Chair. I move House Bill 23-1251. There is no committee report.
To the bill.
Members, 1251 is the work of the Statutory Revision Committee. As its title states, 1251 repeals 3 obsolete provisions and 1 expired definition in Title 39 concerning fiscal policy and taxes. It does not repeal any tax credit that any business or person or entity is receiving, nor does it repeal any provision that any entity, business, or person could receive. It just cleans up the statutes, and we ask for an aye vote on 1251.
Assistant Minority Leader Puglisi.
Thank you, Madam Chair. There's no change to state or local government revenue or expenditures, and there's no fiscal impact. Thank you.
Any further discussion on House Bill 1251? Representative Winter.
Thank you, Madam Chair. I just have one cleanup question. So on page 2, we're striking a bunch of tax language. I was looking at the CRS. I'm sure it has to do with the dates. I just want to double check and make sure it says with respect to the tax years commencing on or after January 1st, 2014, but prior to January 1st, 2022, there is allowed to any person a credit against the tax imposed by this article not to exceed the amount specified in subsection 4 of this section for the conversion of a motor vehicle defined as a Category 1. And I'm not sure if the reason that you guys didn't strike that out was because of the dates set already on it or not. I was just double checking.
Any further discussion on House Bill 1251? Okay. Representative Epps.
Thank you, Madam Chair, and thank you, member, for the clarification. So just to make this nice and plain and on the record, so in Section 1, to conform with the expiration of the tax credit that was already previously allowed for the Category 2 and Category 3 vehicles, Section 1 then repeals the credit and the definitions of those vehicles. Coming into Section 2, repeals the obsolete definition of the Colorado company, not the vehicles related to the LLC, in the law. And then it gets into tax modifications and gains. But your underlying question about, is it just lining it back up? The answer is yes.
Any further discussion on House Bill 1251? Seeing none, the question before us is the adoption of House Bill 1251. All those in favor say aye. Aye. All those opposed, no. House Bill 1251 is passed. Mr. Schiebel, please read the title of House Bill 1032.
House Bill 1032 by Representative Ortiz concerning civil action remedy provisions or civil rights violations of persons with disabilities.
Representative Ortiz.
Madam Chair, it's an honor to serve with you.
Honored to serve with you.
I move House Bill 23-1032 and the Judiciary Committee report.
To the committee report.
Members, in Judiciary, we added 3 amendments. One, that changed a shall cover attorney's fees to prevailing plaintiff from may to shall, so covering attorney's fees to prevailing plaintiff. The next amendment we did was a title fixed. It was a typo from or to for. And then the last was to cross-cite current existing cap for emotional distress damages. That being said, I am running L006, so I move L006 to the committee report.
And ask that it be displayed.
And ask that it be displayed.
Thank you, Representative Ortiz. Members, this is a multi-page amendment that you received within accordance of House rules. Representative Ortiz, please proceed explaining Amendment L6.
Thank you, Madam Chair. So the original version of this bill, I was very supportive of, understood why we needed to do this. Folks, the bottom line is this world is not accessible despite ADA being law for 33 years. So what currently exists is not working. And for having sacrificed everything that I did sacrifice in an oath to this nation and then coming back to be excluded from what I did sacrifice for is a crime, period. And it needs to end, it needs to stop. The poverty rate on average in this nation is, let's see if y'all pay attention, 12% poverty line. 12% of Americans live below the poverty line. Those living with a disability, 25%, nearly double. Why? Do you think I'm lazier? Do you think we're less apt and have less skills to be able to perform and to contribute to society? No. The bottom line is lack of basic access is what is causing these negative outcomes. So the bill as it was, definitely supportive of. That being said, I wanted to make sure that we gave it an opportunity to flush out the more contentious parts of emotional distress damages. We're moving that over to a task force that you'll see in a future bill to discuss with business community, with attorneys, defendants, and plaintiffs to make sure we hash this out and get the best possible piece of legislation around emotional distress damages. We also are leaving it from, or we also are moving it back from being shall cover attorney's fees to may, and leaving it up to the judge to decide when and how that happens. All we're doing in the current state of this bill, and members that are standing at the well should probably pay attention right now, is making sure that we are clarifying what already exists in state statute around exhaustion. Exhaustion is bad. It is killing us, and especially the bureaucratic layer through CCRC that we have to go through can take up to 2 years to try and hear these issues. An example of why they're not effective I can give you right now would be a service dog case. A service dog owner was charged a pet cleaning fee.
Members, if you are having conversations, can you please go outside of the chamber to have those conversations? Thank you.
Okay, so service dog owner was charged a pet cleaning fee by hotel, which admitted to CCRD that it was wrong for. They found discrimination. CCRD finally did find discrimination, but then dismissed it when the hotel wouldn't even come to the table during mandatory conciliation. Folks, this system is not working. We need to make sure we clarify exhaustion. We're not adding anything new. We're clarifying what already exists in statute to make sure that we can either go through administrative means and or take it to trial to make sure we're securing basic access. So I think with this amendment, we are answering a lot of the concerns that were brought up in committee and making sure that we are changing the system or clarifying the system enough to grant satisfaction when it comes to stopping discrimination against people living with a disability and securing basic access. We're also moving the more contentious parts to a task force led by the Lieutenant Governor on a task force that will be bipartisan and that will make sure we discuss these more fully. I urge and I vote on this amendment.
We're on Amendment L6 to the committee report. Representative Holtorf.
Thank you, Madam Chair. And I also rise to do everything we can for our disabled community, particularly our disabled veterans. I appreciate the bill sponsor's passion, and I understand his concerns. Now, I'm going to read this amendment because it is a multi-page amendment. Well, It's a page and a little bit here, and there's some things that we need to make sure we understand, because the original introduced version had Madam Chair, it had significant problems, and they were discussed in judiciary. There were a lot of entities that were against this bill as introduced. A lot of emails came out with expressing concerns about elements of this bill. I'm going through, Madam Chair, some of the papers that were given to me by different organizations and entities and stakeholder groups and they all care about the disabled community. But what they don't want to do is create conditions that hurt economic development, that hurt small business.
Representative Holtorf, I just want to make sure we're talking about the amendment right at this moment. And it, just to remind members, it was passed out on March 14th. So it's barely over a page, and it was received weeks ago. So I just want to remind everyone.
I understand, Madam Chair. I understand. With this particular amendment here, the says on line 7, I'll start there to try to expedite that. No person may file a civil action in a district court in this state based on an alleged discriminatory or unfair practice prohibited by parts 4, 5, and 7 of this Article 34, excluding part 6 of Article 34 and sections 24, 34, 505.6, without first exhausting the proceedings and remedies available to the person under this Part 3, unless the person shows in an action filed in the appropriate district court by clear and convincing evidence, which I think is a higher judicial standard, and I would ask some of our legal beagles to clarify that in this case. So, by clear and convincing evidence, his ill health, which is of such a nature that pursuing administrative remedies would not provide timely and reasonable relief and would cause irreparable harm. Now, the part here that's highlighted, Madam Chair, is still a question, and I'm going to wait to ask this question because I want to get the attention of the bill sponsor in this case. But I know there's important discussion going on. I know that we really care about the disabled community. We want to help them move forward. And this is a question to my colleague, to the bill sponsor. What's that? Okay, that's fine. So to the bill sponsor here, there's a part in this L006 that's highlighted, and this was a concern, and I want to just get a clarification on this, because one of the biggest concerns was the civil action component. The civil action component of this bill and what that means and how that is defined in district court. And says, so in this part it says, this subsection does not apply to civil actions filed in district court based on alleged discriminatory and unfair practice prohibited by either Part 6 of Article 34 or the Section 24, 34, 505.6. So the question was, with respect to these civil actions, they're excluded obviously from the previous part, as I understand, but are they still unbound, limitless? What is the situation with these civil actions, and how is the amendment, how does the amendment address those? Because there was some serious consideration, and I do have some points, some talking points that I can ask further on this with the bill sponsor. But if I could just get clarification on that part of it that's highlighted there in the amendment, I'd appreciate it.
Any further discussion on Amendment L6? Seeing none, the question before us, Representative DeGraff.
Thank you, Madam Chair. I appreciate the bill sponsor bringing this to the floor. I think all means all, and we need to make sure that we include everybody. So anything anything in that we present here, I think just Remember, it needs to be all part of good governance and making sure that we don't end up with any unintended consequences in our zeal. So in that vein, I would like to move L007 to HB 1032 and ask that it be displayed.
Representative DeGraff, we are on Amendment L6. Is this an amendment to L6?
This is an amendment to the amendment.
Okay, so can you move Amendment L7 to Amendment L6 and ask that it be displayed, please?
Yes, I would like to move L7 to L6 and ask that it be displayed.
Thank you, Representative. The amendment is now before us. Please proceed.
Thank you, Madam Chair. This is just to relieve the burden on taxpayers if, for whatever reason, a public employee, a government employee, was determined to have intentionally violated the section, and in which case they will have been considered. So an intentional violation, so it has to be intentional. An intentional violation would be considered to have surrendered their qualified immunity, and then all case evidence in that case would be releasable, so that there's transparency. So again, this would just, so if a government employee was intentionally violating this procedure, this section, then they would lose their qualified immunity. So that way any legal action would not go against taxpayers. It would go instead against the person who is intentionally violating the statute. So I ask for an aye vote on L007.
Representative Soper.
Thank you, Madam Chair. I also rise in support of this amendment. We've talked about qualified immunity quite a bit over the years, and to tell you the truth, this is the most appropriate place where we shouldn't have qualified immunity in statute. When you have a state actor who intentionally makes a place of reasonable accommodation to where that accommodation cannot occur, they should be open to a lawsuit under themselves and not be protected by the immunity that they have stemming from their job by working for either the state government or local government. So this is a good amendment. I certainly believe that if you have someone who's intentionally creating a scenario to where that accommodation cannot play out, absolutely, this is the job of the state to say, we're not going to protect that person. We're not going to stand in the way of that person. We're not going to pay their lawyers' fees. We're not going to pay any damages that result. Because what ends up happening is under the strike below and how the bill changes, so the first thing that has to happen is an order of compliance. Then there's two other provisions that are still left in statute. One is that the court shall consider that the particular guilty party here have to pay actual damages or other damages as well. Why should we as the taxpayers then be on the hook if someone intentionally created that scenario? So that's why this is a good amendment. I stand in support of it and want to thank you for bringing it.
Representative Weissman.
Thank you, Madam Chair. You know, if any member of the body would like to have a conversation about qualified immunity, I'm here for that. I do believe it has become a deeply problematic doctrine as a matter of our federal jurisprudence. Here's the problem with how this amendment relates or doesn't really frankly fails to relate to this bill. Qualified immunity is an aspect of federal doctrine that has grown up around a Section 1983 action, 42 U.S.C. 1983. State action that violates somebody's civil rights. We are not talking about a 1983 action here. We are talking about an attempt to seek relief under state law, CADA, 24-34 and different parts thereof. So whether something is or is not a waiver of qualified immunity is not something that we can speak to as a state statutory matter. That is federal court doctrine that we have to follow whether we like it or not. There was an example a couple years ago where specifically to get around this, we created a state action that in some fact patterns was analogous to, but not Section 1983 specifically. So people trying to vindicate their rights under that action would not be tied up in qualified immunity. So for that reason, that part of this amendment speaking to qualified immunity, or QI for short, just doesn't really work here. The thing that could theoretically work is when we talk about evidence. Now, that is going to be subject to Colorado Rules of Evidence promulgated by our state Supreme Court, and then we go into the Evidence Code 13-90, and we say some things in addition to that for carefully limited reasons. My concern with that part of the amendment is we should not paint so broadly as a statutory matter. Depending on what's going on, there might be some sensitivity about certain evidence. You could possibly imagine a situation where you need a protective order. So again, to sum it up, we can't just, as a state statutory matter, disavow QI, which is federal doctrine. And even if we could, I do not think we should say as a blanket matter that all case evidence will be publicly disclosed. Not that where there's intentional violation of somebody's civil rights, there's necessarily a ton of sympathy to somebody doing that. But really what I'm concerned about here is the complainant might have some privacy interests in matters, in evidentiary questions that they would not want aired all the way fully out. At any rate, I think that needs to be determined case by case, and we can't just paint with this broad of a brush. So for those two reasons, I need to ask for a no vote on L7.
Representative Luck.
Thank you, Madam Chair. So I didn't have any input into this amendment, and I haven't talked to the amendment sponsor, so I don't know for sure. But this may be addressing an issue that was brought out in committee. There was a conversation around how there are different situations within businesses, maybe a bar in the bathroom being an inch too high or an inch too low, that actually had an intersection between the actions of the business owner and the actions of the government inspector, the employees who were supposed to make sure that all of the different requirements were indeed met. And so I don't know, again, what the amendment sponsor had in mind when this amendment was drafted, but that is an issue that we do need to wrestle with, and that I think maybe this amendment seeks to wrestle with, which is what responsibility should the government actors have in ensuring that standards are met in accordance with ADA, and that when those standards aren't met and yet a good faith business owner or public accommodation sought the government's inspection and got approval, and those inspections actually ended up to be false, wrong, they didn't do their job, should the business owner be the one who is responsible in that instance, or should the government actor be the one that's responsible in those instances? And if it's a mixture, what should that mixture be? Again, I don't know that this is what the amendment sponsor had in mind, but I do think that it is an amendment or a conversation that needs to be fleshed out.
Representative DeGraff.
Can't keep up. That would be part of it. That instance that my colleague is representing, it would be something I would put, like if you read your, considering it is tax season, if you read your tax booklets and then you call the IRS because it is completely unclear how to do it. There's actually a caveat in there, and this is to the bill, this is to the amendment. There's actually a caveat that whatever the IRS tells you to do, they're not legally bound to that advice. So it is possible that it is possible in this case, in any case, that a well-intentioned, the business owner can make a determination based on what should be the expert guidance of the government, the inspector, and then that turn out to be wrong. So in that case, if the inspector has signed off, everything is good, ADA compliant, et cetera, then really it would not be proper to hold the business owner. More to this would be just a recent case with Social Security and a constituent with PTSD, and the Social Security Administration precluding them from getting the benefits, and then keeping that away for months until I get involved, and then all of a sudden it can be handled with just a stroke of the keyboard, and then all of a sudden it's handled after 3 months and many phone calls. So it's so there is the advice part, there is the inspection part, and then there's also the aspect of we do have people in positions of power, and sometimes they're just malevolent. And if that's the case, and that can be shown to be intentional, then the public should not be bearing the cost of a lawsuit. And then, of course, what that would hopefully do is by removing that veil of immunity, then hopefully that would dissuade anybody from recreational persecution, you might call it. So, so I do ask for an aye vote.
Representative Ortiz.
Thank you, members, and I appreciate the robust discussion with this amendment. I would ask for a no vote on this amendment, as it would be a poison pill to this bill. I do appreciate the discussion, so I definitely am open to making sure this gets discussed in the task force in a more full way, so we can vet this and discuss what it truly looks like in a more sustainable way. To answer the earlier question of another colleague of mine, both Part 6 and 505.6 already have exceptions for civil action. We're simply clarifying that. Things aren't boundless or limitless. They're limited by remedies already available under the law. We are just clarifying what already exists under the law, that exhaustion is not the only way or not the path required first before seeking a remedy, that you can also take this to court. So again, I urge a no on L007 to Amendment L006, and once we kill this amendment, a yes on L006.
Is there any further discussion? Representative Holtorf.
Thank you, Madam Chair, and thank you to the bill sponsor for that clarification. That does help as we navigate this complex issue. I will tell you that there's something about this amendment that I think has real value, and I don't know how it gets incorporated either in this piece of legislation or in the task force. There would have to be somebody that understands the issue and is not from the state government in this case. In so much legislation and work that we do, there is liability, and the state has liability. Members and employees of the state government, executive directors, members of even employees of the state that are in charge of different programs, be them programs that are in one department or the other, CDPHE, DHS, HICPUF. There's just so many departments out there, and government's growing, as we know. I believe by 8% now is the growth in this last iteration with respect to the budget and the number of employees that are now coming to work for state government. But one of the issues that we have here, and I had somebody tell me this from OLLS staff, and they said it this way, which is striking to me, and it struck me, ladies and gentlemen of this chamber. They said, oh, well, you can't do that because you can't sue the king. Now, this is a metaphor. Don't want anybody to misunderstand me, or I don't want anybody to grab the gavel and hit it down on that piece of wood back there. It's a metaphor. But they said, quote, you can't sue the king. And I thought, well, what if the king is the one causing the problem? And the king's court, and the king's men, and Humpty Dumpty, well, you know the rest of the story, Madam Chair, falls off the wall, has a great fall. But anyway, not to tell rhymes, although they have been done here in the well before. The issue here is when the state and employees of the state have liability, why not? Why not say, you know what? You don't get qualified immunity. I mean, Madam Chair, we took it away from law enforcement. Why Why can't we take it away from these people? Precedence has been set already, ladies and gentlemen, in this state. Take it away and hold them liable. You know, law enforcement has a real hard job. These folks in state government have a real hard job, but they don't get to hide behind that because now their necks are on the line. How about that equity? Ooh la la. How about it? But this bill right here, I mean this amendment rather, it does that. It says, you know what? You don't get to hide behind it. Even in state government, you don't get to hide behind it. And that's why I like this amendment so much. And it's truly something that has merit. I don't know how it fits. I don't know where it fits. I'm not a lawyer. But when someone tells me you can't sue the king, I say, you know what? Maybe the king and his court and his merry men do need to be held accountable with this liability. And that would only, in this case, help this bill move forward, I think. Because now everybody's on notice for what my colleague from Arapahoe County is so passionate about. And we do want to support it to the great extent possible. So with that, I encourage an aye vote on this. And if not, how this consideration for this would fit in future time is very important to the conversation.
Is there any further discussion? Seeing none, the question before us is the passage of L7. All those in favor, please say aye. Aye. All opposed, please say no. No. The amendment fails. To Amendment L6. Is there any further discussion? Representative Luck.
Thank you, Madam Chair, and thank you to my colleague from Delta for yielding the will. So there is a question around the exclusion of Part 6 from this particular bill. So if you guys are aware, this is all touching on CADA, the Colorado Anti-Discrimination Act, and the CCRC, the CCRD, the Colorado Civil Rights Division, and the Colorado Civil Rights Commission. And so under this bill, what is being authorized is for complainants to go directly to district court and not go through the CCRC system, not go through the commission with a complaint, but to go directly to district court in the event that that person's ill health is of such a nature that pursuing administrative remedies would not provide timely and reasonable relief and would cause irreparable harm. So in that exception, they can go directly to district court and skip the administrative law process. The question that I have posed and would just like to state on the record to the bill sponsor is why are we including parts 4, 5, and 7, which include employment, housing, and advertising as exclusions that if you have a complaint under those 3 categories, you can go directly to court, and not including Part 6, which touches on public accommodations. The reason why this is relevant to me is because more than likely in my mind, a lot of these complainants will have complaints against places of public accommodation more than, let's say, advertisers. So why would we give them this extra ability to go straight to district court and skip the administrative process if for advertising, but not for something more substantial like public accommodations? And so that was the question that I posed to the bill sponsor, and he was happy enough to oblige with an answer. So thank you.
Representative Ortiz.
Thank you, Madam Chair, and I want to thank my colleague for the question. We're not. They're included in the exception for claims under Part 6. All claims against public accommodations and public entities under this language can go directly to court. The original drafting of Section 6 excluded public accommodations from exhaustion. Then courts got confused because of other changes. Just like at the federal level, ADA violations in places of public accommodation don't require exhaustion.
Sorry. Can you hear me? Representative Bradley, sorry.
Thank you, Madam Chair. A couple of questions for the bill sponsor, and I do appreciate you cleaning up the language. How long does a business owner have right now to fix an ADA complaint?
Sorry.
Okay. And then,
Representative Bradley.
Thank you, Madam Chair. Can you get me the statistics on businesses that don't fix the violation? Because I guess my problem is we're going to move away from a complaint going straight into litigation. You know, a lot of the paperwork that or emails that I've gotten from so many people regarding this. And again, as an able-bodied person, I believe that everything should be accessible to anyone. I think that businesses should want to do that. And I read a couple of quotes from attorney Courtney Patterson that says that business owners especially should want to be compliant. She recounted representing more than 35 businesses, mostly owned by minorities, women, or the elderly, that were sued for Americans with Disabilities Act violations. Nearly every case was brought by out-of-state attorneys representing out-of-state plaintiffs. That's a big problem to me. A couple of examples. Moshe Kirsch owns property in Lakewood. He said the first notice he received of any ADA problem came in a notice from an out-of-state attorney that he was being sued. They sent me a letter demanding $10,000 for dropping the lawsuit in hopes I would be scared enough to give into the extortion, he said. This shows that the entire lawsuit was never for the benefit of disabled people, but intimidation tactics to collect an easy money settlement. Azita Nachiri, who operates Saffron Grill in Lakewood, expressed similar skepticism that the lawsuit filed against her restaurant was truly intended to benefit the disabled. We changed the problem very quickly, she said. I care about my customers. Why don't they give us time to change? Patterson said the business she represented thought they were in compliance with ADA because they had received a certificate of occupancy. These lawsuits try to scare the business owners into settling quickly for $10,000 to $15,000 rather than face long, expensive litigation, she said. To a big corporation, that's not a big deal, but to these small, locally owned businesses, $10,000 to $15,000 could break them. And honestly, we have lost so many small businesses in the last couple of years. I have to get up here and fight for some small businesses. Business owners described letters from out-of-state attorneys citing a litany of ADA violations, many of which were obviously false, lending further doubt about whether the plaintiff has ever set foot in the business. Businesses know they have to set aside ADA parking spots, but if they put their signs at 55 inches rather than 60, they can be sued, Patterson said. They know they have to put grab bars in their bathrooms, but if it's an inch too high or too low, they can be sued. If plaintiffs' attorneys can suddenly seek eye-popping emotional damages of more than $500,000, even when damages are neither blatant or obvious, an avalanche of drive-by lawsuits is expected. So I guess my question, if it's not working, if filing a complaint with the ADA and you're finding businesses are not fixing them, I'd like to understand how many businesses just won't fix the problem and instead litigation is the appropriate response. And then again, how long does a business owner have to fix an ADA complaint? Thank you.
Representative Ortiz.
Loath to come up here and answer that question, especially when I get accused or when there's accusations of extortion going around. It's not like I am making, or those of us that live with a disability are making millions of dollars off of these claims. So that's utterly ridiculous. Let's be careful about the language that we choose and careful about what language from constituents that we choose to elevate. Because bottom line is businesses have had 33 years to become compliant. The short answer, though, is 30 days. They have 30 days to come into compliance once there's a violation.
Okay, I will caution that we can talk about questions, but let's try to stay away from accusations of what a bill does. I will go back to Representative Bradley, and then we have Representative Soper.
Thank you, Madam Chair. And I was not doing any extortion, and I don't appreciate my character being impugned at the well. I was quoting from an article by an attorney who has had 35 businesses that she has filed lawsuits for that were brought by out-of-state attorneys. I was reading from an article, everyone. I would still like to understand the statistics. You said 30 days. How many businesses are out of compliance for doing that? And why do we have to go straight into litigation? That was the question. Thank you.
Okay, thank you. And again, I will provide that caution for us all. We are here to debate a bill. We can bring forward information, ask questions. Thank you all for engaging. I'll go next to Representative Soper.
Thank you, Madam Chair, and it's an honor to serve with you.
Such an honor, my friend.
So members, I first want to say I greatly appreciate the strike below in Amendment L006, which we're currently debating. It does several things that I just want to highlight for the record that gives me reassurances in the direction that we're heading. So first of all, emotional damages were part of the original bill, and that's been struck out by Amendment 6. And then second of all, attorney's fees have also been taken out by Amendment 6. And then if you're looking at the first part under Section 1 in the amendment, if you're in housing, employment, or advertisements, you still have to go through the CCRD, the Colorado Civil Rights Division. But then if you drop down to Part 6, for public accommodation claims, you have the option of either going through the CCRD or going directly to district court. Under current law, there then would be three things the court could order. One would be compliance with the provisions of this section, so fixing whatever is the ADA deficiency, so a ramp, making sure that you have Braille. Two would be recovery of actual monetary damages. So let's say you were injured by there not being a ramp. So whatever those actual damages would be. And then three would be a fine, a statutory fine of $3,500. So these are the three provisions under current law that the court would have the ability to order. Under Amendment 6, we're making number 1 a mandatory. So the court must order compliance with the provisions herein. So the business or the entity has to make the correction. Is that correct? And then at the bottom of page 1 of the amendment, it then talks about then the court can order requiring compliance with the provisions of the applicable section, and either 2 or 3, the old 2 and the old 3, so they would either award actual monetary damages or the statutory fine of $3,500. So if you're an entity, a business entity that's been sued, you know you're going to have to correct what's wrong. And then you're also going to know that you're going to be on the hook for one of these other two damages, actual damages or the statutory fine. And you know that that's going to be in place there. However, one thing is now that we've made number 1 mandatory, we should make 2 and 3 at the discretion of the court that they may award, not that, that there's a mandate that they must award. So that's why, Madam Chair, I move Amendment L008 and ask that it be displayed.
Proper motion. Okay, to the amendment.
Thank you, Madam Chair. So what this amendment does is, at the bottom of Amendment 6, page 1, it says a court order requiring compliance with the provisions of the applicable section. And then after and, we say, applicable section and may be awarded either actual damages or a statutory fine of $3,500. This allows the courts to have full discretion about what they're going to award, because already by the amendment itself, Amendment 6, we've already made it mandatory that the actual compliance with whatever the deficiency is in Americans with Disabilities Act. So that business has to remedy what it is that they're not in compliance with. And in talks with the proponents, that really is the core of what they're driving at. And then if the court actually sees actual damages, they can still go ahead and award those. If they believe that, in this case, the business owner was acting with extreme harm or indifference or being intentional, you pick your favorite word from law and put in there, then the court may go ahead and award the $3,500 in statutory damages. But this puts that decision back in the hands of the court. So as the business entity, you know for sure you're on the hook for compliance, and then the rest you would still have to make your argument before the court as to are you going to be paying actual damages or statutory fines. And I'd ask for a yes vote. Thank you.
Representative Ortiz.
Thank you, members, and I do appreciate my colleague for opening this side of the discussion. The bottom line is it's not like we're money bags, folks, those of us who live with a disability. $3,500 fine and this relief here is making it or incentivizing to make sure that we create a state that actually is creating meaningful basic access. We're talking about basic access, folks, at the end of the day. Like, I am talking about being able to get into restaurants or to get into my place of work. I'm not asking for them to install an elevator so I can get upstairs to their outside portion of the bar, okay? And the bottom line is the current system is not working, even though ADA has been law for 33 years. So I do appreciate the amendment. Again, this can be something that we discuss in the task force if that's something that my colleague is open to. But for this version of the bill, I'm asking for a no vote on this amendment.
Representative Soper.
Thank you, Madam Chair. And just to my colleague from Denver, one thing I would say is that this is a very minor change. It still keeps it in the hands of the court's discretion, and I think that's most important. But one thing I just want to say that I fully agree with, that you hit on, that I hope the whole world hears that this body is hitting on, and that's the fact that after 33 years, it is unacceptable that for some of these businesses, they have yet to take steps to make them ADA compliant. And that's why, I fully agree. Having it mandatory that they have to comply is the most important step there, because compliance can cost tens or hundreds of thousands of dollars. And that's, for a lot of small businesses, that is going to be quite a hurdle to overcome. I can remember when I am with the local Elks Club in Delta, and we decided to go ahead and install an elevator. And given the fact that it was an old building built in the 1890s, as members, it's not like even pooling our money, we had many resources. So it was a multi-year capital campaign to be able to raise the near $500,000 to be able to refurbish a portion of the outside of the building and to be able to install an elevator that went from the outside all the way up to the different floors to be able to make it accessible. And that pushing the actual compliance is really what we want to see done as a state. And then to be hit with the possibility of, it's either going to be an actual damage or a $3,500 fine on top of that. From the business point of view, if you've just spent $500,000 for the actual compliance, you almost view that as insult to injury, and that it really should be the court on a case-by-case basis who actually decides, okay, was this entity acting in a reckless way, intentionally not changing their business to be able to have the accommodation that they should have granted? I mean, if the answers to all those were no, the entity should just be on the hook for actual compliance. And that's why having this left to the courts to be able to decide on a case-by-case basis is important. And I'd ask for a yes vote. Thank you.
Thank you. And our colleague is from Arapahoe County, not Denver. Representative DeGraff.
Thank you, Madam Chair. And just for clarity, in speaking with my colleague, the lawsuits that were discussed were from out-of-state lawyers that were just not from individuals that were, not from disabled individuals that were looking to exploit the system, but for unscrupulous people looking to exploit the system. And regarding this amendment, which may be awarded in this case-by-case, making this more of a case-by-case basis, that's not accusing any persons with disabilities. I think it's great. There was a time in our society when people with disabilities were intentionally locked away. That was part of the thinging of people, making them things, and that was part of the eugenics movement. So I'm glad that we're getting back to this, that we're welcoming, and that all means all, and that the purpose of government is to secure the rights of the individuals in this case. But we have to go back to that these laws don't really care about intent. What they care about is what's in black and white, or black and yellow on this page here. So that's what we're trying to hammer out. We're not trying to we're not trying to restrict anybody from having access. I do have some questions about. I have some further questions about this, but to this aspect of here of may be awarded, I think it's important that we have just like the my colleague noted before, that we don't want to have this. We don't want to have an exhaustive procedure process before we get to any remedy. We also don't want to have an all-encompassing, you get hit with everything and the kitchen sink sort of legislation. So this is not to mitigate. I don't see this as a mitigation of the cause. I don't see this as a denigration of intent. This is purely to make sure that there's some flexibility in here, so everybody's not painted under the broad brush for litigation. So I have other questions regarding the bill itself, but I would recommend an aye vote on this, not to encourage discrimination. That's not the intent. It's just for good governance. Make sure that I think this addition is more in line of what the sponsor actually intends. The sponsor does not have any. I believe the sponsor does not have any intent of lawfare in any way, shape, or form. This just precludes other people from doing that. Thank you.
Thank you, Representative DeGraff. Representative Bottoms.
Thank you, Madam Chair. I agree with previous representative. I don't think the sponsor is trying to develop something that will be a litigious explosion or something like that. I don't think that's what's going on. But I do know from personal experience, 2 different times over the years, anytime I am in charge of a facility, a church or other facility, first thing I do is try to bring it up to whatever code it has not been brought up to, and specifically ADA. So that's the first thing, and obviously as a pastor, I want people being able to come into my church, and so immediately I will work on that, and I've done that a handful of times. And one time in particular, brought everything up to code, hired a company to do this exactly the way the code is written, and had an inspector come out and drive by, not even get out of his car, look at what we had done, and failed us on the inspection. Didn't measure anything, didn't do anything, failed us. And so under this bill, that makes me now potentially liable. We petitioned, got another inspector to come out. It took months, because that's how inspectors work, and that's how code works. And came out and said, yes, this is in full compliance, measured everything, did everything just fine. But during that time frame, I would have been liable under this bill.
Representative Bottoms, I just want to note that we are on L8, and the language particularly talks about an insert of may be awarded in court, not necessarily on the bill.
Right. So that's why I'm in favor of this amendment, because it takes that liability away from me. It gives this, that it may be, that means it has to come before somebody a few layers in before making me liable. So may be awarded is huge language for somebody that's actually trying to be compliant. We're trying to get the job done the way that it needs to be done. So I strongly in favor of this amendment. We need to kind of back off on the potential. Again, I'm not saying the sponsor is trying to make everybody liable for lawsuit, but that will happen in the case of this. And so this may be awarded I think is very important language to go along with this. So I do speak in favor of this amendment.
Thank you. Representative Luck.
Thank you, Madam Chair. I keep wanting to call you Madam Speaker.
In my dreams. No, I'm kidding. Keep to the bill, to the amendment. Sorry.
So I too rise in support of this amendment. As my colleague from Delta clearly laid out the current situation, there are 3 remedies the court could choose from now. They're not required to choose any of those remedies, but they could choose all or one or all of those, right? And so it's an interesting situation because I completely agree with my colleague from Arapahoe County that the situation has to change, right? That there have to be amendments to this, that it has to be adjudicated, that the current situation isn't enough. But what is ironic and interesting about the current situation is that the court has discretion as to whether to order compliance. They don't have to order compliance under the current law. And so by saying to the court, you have to order compliance, that is what you have to do in order to pass go and collect $200, and then give them discretion as to damages, I think that is a good first step in trying to address this. And the reason I say that is because under the CCRC system, if a complaint is filed, the defendant in that case has to pay for legal costs. They have to hire their own attorney. They have to engage all of those fees. The complainant in that situation does not have to do that. The CCRC or the state actually covers those costs. And so regardless, even in the best case scenario, the CCRC situation, which probably is going to be less costly than a court situation, they still have to incur those costs. They also have to incur the costs, as was noted prior, of the actual fixes of complying. And that could be something very simple and cheap, or it could be something much greater than that. And so I think it's important to give discretion. And here's one of the situations I have in my mind. So in committee, we heard from businesses, and one of the businesses remarked that their issue was a sign that was just a parking sign, a handicap accessible parking sign that was just a little too short. Another business remarked that there was a bar that was an inch too high or too low. Those things are significant, and I'm not minimizing that. We heard from the disability community, and we heard how significant that is in terms of granting access. I'm not in any way minimizing that. I am, however, saying that sometimes they are that small of a situation in terms of the broader cost, because we also heard from some who talked about how there are companies that are building even today that aren't in compliance, right? That they're building whole structures that aren't in compliance. That would require, I think, much more stringent damages if you're building from whole cloth. But these individuals who are talking to us, they talked and they shared about inspectors coming right to their business, or that business being in operation, and them inheriting it, and inspector upon inspector came and there was no issue. And so I just think about this, and I think about the affordability for all that Governor Polis had mentioned. And when you pile cost upon cost upon cost to these small businesses, what does that actually do in terms of their ability to continue, even when they made a good faith effort to be in compliance? And so if they made a good faith effort to be in compliance, they thought they were in compliance, the inspector said that they were in compliance, now they're finding themselves in front of a court or the commission, and they're having to pay those different fees in order to learn that they weren't actually in compliance. And hopefully they were just able to cure it, right? But maybe they weren't. And now to add on that a mandatory damage award, I think that is potentially too burdensome for all of the situations. There may be situations where piling on the damages are appropriate because people have acted egregiously and they have acted with impunity and just thrown caution to the wind and care for their community to the wind. And in those instances, I say absolutely throw the book at them and make them pay for that. But in some instances where people genuinely thought that they were in compliance and they made a good faith effort, I do think that the court should take those factors into account and be able to avoid adding additional layers of damages. Thank you.
Thank you. Representative Taggart.
Thank you, Madam Chair. This paragraph 24-34-306 makes me want to finish my law degree because it's one of the most difficult paragraphs that I've read since I've been here. And I would just like to rise in support of this amendment. If this Part 6 is not going to go through the administrative process and is going to go directly to district court, as a layperson, I think it should be up to the judge to determine by the evidence if the defendant has ignored a request for a period of time, or this is the very first request, to make a decision whether there should be any penalties above making the proper changes to be ADA compliant. If we trust our judges, if we trust the court, this just doesn't seem unreasonable, especially if this was the very first time the complaint came before the court and there was, it had not been brought to the defendant's attention over and over and over again, and they can figure that out. It seems like a very reasonable request. Thank you.
Is there any further discussion on Amendment L8? Seeing none, the question before us is its passage. All those in favor, please say aye. Aye. All those opposed say no. No. The amendment fails. To Amendment L6. Is there any further discussion? Representative Ortiz.
I urge an aye vote.
Is there any further discussion on Amendment L6? Seeing some. Representative DeGraff.
All right, since this is essentially the bill now, I do get that we're trying to avoid this exhausting part, but I do see below here that it's categorized, or caveated rather, on ill health. And I'm curious on here whether disability and ill health are being the same, or if ill health is different in this case, because in this case, somebody who has a disability but not ill health might still be subject to that. And then also, I am a little concerned in general, and we've touched on this, because violations, penalties, and immunity, an individual with a disability, as defined per that, must not, and disability is quite broad. I mean, there is a really wide range of disabilities that people can have that, again, you know, we want to welcome everybody to participate in life to the max of their ability, but when somebody gets a zoning, they get a certificate of occupancy that says that they have had, that they are in compliance with the ADA and the zoning, they should be able, in the zoning requirements, that should be some level of protection for them. So if a business, and what I don't see in here is that if a business is found to be not accommodating a disability, and we don't know what that disability is, and having gone back and looked at that section, I didn't see that it was a comprehensive list. So I think this becomes overly broad in that regard. Not that we don't want people to participate, not that this bill has ill intent. I don't think it does at all. While I trust the sponsor with this bill, I don't trust everybody out there with the wording of this bill. And I think we need to have, if we're going to allow litigation based on disability, we probably need to define what that disability is. If somebody's blind, well, of course, then they have to, you have to have Braille signs. If somebody is in a wheelchair, you have to have ramps or elevators or something else. But if somebody is completely paralyzed, well, that would be a disability, but is a business required to accommodate that? So again, I think it's fantastic that we're bringing this up. So this is not against the bill. This is just clarifying it so we don't have opportunists harassing our businesses for profit. Not that that has nothing to do with the sponsor or the disabled community. It just has to do with the nature of the society that we live in. So I think we need to have disability a little bit better defined, and also my question between disability and ill health. I'm curious as to how those relate.
Thank you. Representative Soper.
Well, thank you, Madam Chair. So I was hoping our last amendment would have been accepted. It certainly would have improved things. You see, members, there's another bill that's already making its way to the governor's desk. It might already be there, Senate Bill 244, which we already considered. And it actually touches on this particular part of statute 24-34-802.
I would caution us to stay within the confines of this bill to the extent possible.
Sure.
Thank you.
Thank you, Madam Chair. I just referenced the other bill because the two are actually companion bills, and so they actually work together. And so it is really good to think about how law is going to operate together. It's important to also understand, if you were thinking back to the bill, that we have a statutory construct that says the later bill prevails, which means that the changes that we're making to this particular part in statute, assuming this makes it to the governor's desk, will prevail over what we considered in a previous a piece of legislation that we voted on here just a couple weeks ago. The part that I would really like to hit on here is we're making a pretty significant change. So it used to be you had to go through the Colorado Civil Rights Division, and then they would come out and they would investigate that business, and they would see whether or not they were in violation, issue their report to the business, and then the business would need to take steps to address whatever the complaint was based on. And if they didn't, then they could go ahead and be sued and brought before district court, and then the facts would be brought out in district court, and some of those facts would be that they failed to comply with the findings of the CCRD. Under the changes that are considered here in Amendment 6, we now have a scenario where a plaintiff can elect to either make a complaint through the CCRD process, or they can file directly with district court. In filing immediately with district court, for many business entities, this will probably be the first time ever they've ever been told or warned that they're out of compliance. And I know we've had the conversation about 33 years since the ADA was enacted, but there are some issues where that particular business, they honestly believe they are in compliant. Like, for example, the wheelchair ramp may not meet the right grade, but yet they say we have one. Well, it would really help if you had the Civil Rights Division who said this actually doesn't meet code, and work with that particular business entity first, rather than now being dragged into district court. They then get to the end of district court under the amendment, which is the bill because it's a strike below. Now, all of a sudden, they are required, the court is required to have actual compliance. So whatever wasn't part of, say, local code or state code has to be brought up to that state code, and, that's the key word, and, because this is what we had the discussion over with the previous amendment, and the court must award either actual damages or statutory damages. If the entity is a bad actor, absolutely, I want them to have to pay. But for the person who said, hey, I had a wheelchair ramp. I thought I was in compliance. I was doing all the right things. And then they find out later it was not perfectly up to code. Now they're on the hook for insult to injury, as it were. Litigation really ought to be the last resort to solving problems. As we've heard over and over again, better problems are solved really before you get to the confrontational stages of the courthouse. And then, really, if the goal is to change how businesses get notice, you should not be getting notice that you're out of compliance with the ADA by having the summons and complaint served on you. That shouldn't be the first time you're hearing that you're not in compliance with the ADA. That's why the CCRD process is actually an important process. That's the means by having official notice of, hey, you're not in compliance. And then, certainly one thing we always worry about is, Colorado businesses being subjected to more lawsuits. I believe the amendment addresses a lot of concerns. The emotional damage element and attorney's fees were ones that were of great concern, and certainly to our small business community. But just the fact that you're getting a summons and complaint and you're being pulled in front of the courts, that now means as a business, a small business, you have to go out, you have to hire an attorney. You're now preparing for what could be a lengthy court process, and that attorney is going to charge court attorney's fees, so the highest out there. You're going to go through discovery, particularly if it's a case of, say, a wheelchair ramp not being at quite the right grade. I don't think there's any sort of a substantial compliance defense. At least I certainly didn't see it when I did my research for this bill. But you're going to have to do all that research, have all that argument, all that prep work. So for the business alone, they're going to be sufficiently punished by their own attorney's fees. And then they show up in court, and then they're going to be mandated, because the court has to mandate the correction, which I'm in support of. And then they're still going to be on the hook for actual damages or statutory damages. And the element of, there's nothing in here that says a business couldn't settle as well, by the way. That's kind of the irony here, is that a business may look at how much it's going to cost them in their own attorney's fees, and they might be looking at how much it's going to cost for actual compliance. Why wouldn't the business go ahead and try to have a quick settlement? That would be one thing to make the problem go away, which is why it was much better to have the complaint process through the Civil Rights Division, so that then that way you had already built the record that they needed to comply. So for these reasons, I'm going to be against the bill and the amendment. I think we worked hard to try to address these concerns with a simple 3-word change. We didn't quite get there. I would have loved to have had some broad bipartisan support of this, but unfortunately, the exposure that this gives our businesses, particularly our small businesses, our mom and pop stores throughout Colorado, is troubling. And the fact that we're certainly opening more businesses up to lawsuits is also troubling. So for these reasons, I'm going to be a no vote. And thank you for a great debate.
Thank you. Is there any further? Representative Holdsworth.
Thank you, Madam Chair. And I really appreciate what the bill sponsor is doing with this. I think what the bill sponsor is trying to do, and I'm not going to speak for him, I wouldn't do that. I do have a really good relationship with the bill sponsor, and that's important to me. But I think what the bill sponsor is trying to do is say, the things we've done haven't worked, and so now we have to get more aggressive with the action that needs to be done with respect to statute so we can get more compliance. And there's a lot of challenges in the disability community, and I think we have made inroads in many areas. But my previous colleague here made a very important point, and I want to reiterate that point, but I also have an article here that was given to me, and I believe it still has merit even with this, with the amendment L006, because it is a real concern. It's a real concern for many of the stakeholders that have reached out to me. But maybe it's not as a concern based on the language, and the bill sponsor can let me know this. But truly, if you think about, I mean, it wasn't that long ago we did a tribute to small business as we try to help promote small business. As small business tries to recover from, you know, and some people do say that we still haven't recovered from COVID. Economically, the economic recovery post-COVID still hasn't been done. And you know, it could take years in some cases. Many of those businesses aren't coming back. But with respect to the liability, and I agree, if you have an ADA compliance issue, as a small business owner, the first thing I would want to get is maybe a call or a letter or some correspondence from a department or administration that says you have these compliance issues and you need to seek remedy under federal law, American for Disabilities Act, or state law. And that here is the time frame to get compliance. So that particular small business, or medium-sized business or large business, but I'm going to speak to small business because that's what we have primarily in rural Colorado. We have small businesses, lots of small businesses. That's the fabric of our communities, our towns, our small towns and such are built around these small businesses. And truly, even in many towns in rural Colorado, there probably are still issues out there. If my colleague from Arapahoe County was to come to any one of my small towns, I'm pretty sure there would be challenges that would still be there. What you wouldn't want to see is a letter from a legal entity that says, we're filing civil action against you because you have failed to comply with a state statute or a federal statute. That's just not the right direction. Although I want us to move. I think the element of this that has the working group to try to figure out how to move forward is important. I'm in support of that, 100%. To my colleague, 100%. Legit, 100%. Did I just say legit, Madam Chair? I don't think that's even the right language.
Unless
Legitimate.
you will quit.
Is that the right way to say that? Legitimate? I was just seeing if you're awake back there, ma'am. Anyway, all joking aside, this article was, and this is troubling to me, and I'm going to ask everybody to bear with me, because I was asked to read this article. And I'm like, you know, I don't really want to read this. But you've asked me to, so I will. And it's dated, and it isn't even Colorado.
Representative Holtorf, is the Article 2 making public accommodations?
It talks about small businesses and the conundrum that is civil actions filed in courts based on alleged discrimination or unfair practices by legal entities. So I believe it's relevant to the L006.
I may interrupt if it does not talk about accommodations for disabilities, but please go ahead.
And Madam Chair, I would welcome any interruption if needed. because I do appreciate your leadership. Anyway, and I'll try to navigate this in a way that is as professional as possible. But this particular article is March 21st, 2023. It's actually Courthouse News is the reference. Under Judicial Reports and Opinions. And I don't know if you've heard of the Courthouse News or not. It's a syndicated news outlet for legal issues and actions and things that happen in the legal world. And I don't subscribe to it. I'd much rather get the Ag Journal or the Fence Post or,
the article.
Colorado Cattlemen's. Yes, ma'am. Anyway, my heart is in agriculture, as you know, ma'am. But I'm going to get back to this right here. This is it says law firms accused of ADA shakedown of small business. In this particular article, colleagues, it says that a law firm, and I'm not going to name the law firm. I'm going to, because I don't want to impugn anybody. I know there's law firms that are shady out there.
To the article.
Yes, ma'am. But I'm not going to name this name. Okay, this law firm is accused of bombarding California small businesses with thousands of fraudulent disability rights lawsuits under the pseudonym Center for Disability Access. Now, remember, this is me reading the article. And now, ironically, this is out of San Francisco. You'd think if any city in the United States would get it right, it should be San Francisco. Anyway, this particular law firm demanded cash payments from small business. In this case, the district attorneys of San Francisco and Los Angeles. And this is interesting because we have to be awful careful how this goes, because then you get more legal action, Madam Chair. And you're, I believe, a lawyer, so you'd understand this a lot better than I would. But San Francisco and Los Angeles district attorneys are seeking the return of, hold on, millions of dollars that owners paid to settle thousands of groundless disability lawsuits in California. The lawsuit filed jointly by the San Francisco District Attorney, and I'm not going to name that person's name, and the Los Angeles District Attorney. Everybody knows Gascon, so I guess it doesn't matter if I name that one or not, all over the United States. In San Francisco, Superior Court claimed the firm, named to not be released, filed thousands of boilerplate American with Disabilities Act lawsuits on behalf of a handful of disabled clients against small businesses, and then pressured the owners, hold on, I lost my place. I got to read this. Excuse me, ma'am. Okay. Let me get back to where I was here.
As long as you can tie it to the bill.
Yes, ma'am. I got distracted by the yellow sticky. Okay, I've found my place, ma'am. On behalf of a handful of disabled clients against small business, pressure the owners to settle as quickly as possible an amount between $10,000 and $20,000. Now that's a strategic number, and it's troubling. I wouldn't want that to come to Colorado. I wouldn't want that to come to small businesses in Colorado who have suffered and struggled and now are trying to get back on their feet and move forward in this post-COVID economy. Now, Madam Chair, and I'm going to wrap this up for my colleagues and leadership on my side of the aisle here as quickly as I can. But this resulted in over $5 million extracted from California small businesses on behalf of these serial filers in just 2 years. In 24 months, this particular entity, under a pseudonym, and that's a fake name, not who they really are, Center for Disability Access, which sounds really legitimate and important. $5 million in 2 years. And that's just for just one of the serial filers, just one. This is a lot more than just millions of dollars. This is tens, if not hundreds of millions of dollars across the state of California. So this is serious, and that's why I was asked to bring this forward. I think that's still embodied in this particular legislation, although I think L006 is better than where we were before. Now, I'm going to speed things up here a little bit. Of another client, filed more than 800 lawsuits under this pseudonym. Well, there's more, members of the chamber. There's more. Allow me to continue. Another client, named to not be mentioned, filed more than 1,700 cases. This particular said that previously there was a federal grand jury that indicted these particular clients because they failed to report income they'd received from all these many, many lawsuits, tunes of millions and millions of dollars. So how do we prevent from fraudulent lawsuits? And I think this is something to the bill sponsor that this working group better think about. You know, fraud's not okay, extortion's not okay, a mafia-style shakedown's not okay, even from lawyers. I call them predatory lawyers. I got other names for them, ma'am, but I can't say them here at the well.
Thank you. To the amendment.
Yes, ma'am. But this is a problem in this country. And potentially, if we're not careful with this legislation, it will become a problem for Colorado small businesses. And they'll be out there just waiting like a hungry wolf trying to eat an innocent little calf out in the cow pasture. I saw some of those this weekend, ma'am. A lot of baby calves out there bucking and running. But I'm going to wrap this up here. I'm going right here. I'm going to go to the bottom of this because I know we've got some things to do today. There was a lot of denial of this, but the truth is, and in one specific example that my colleague mentioned earlier was this 12.5% ramp to the front door. It was allegedly too steep. Well, a letter from some agency saying, hey, it needs to be whatever the grade is, and I'm sure my colleague knows, I don't know, 8%, 6% grade. I know there's things that are standards for that need to be followed. But they don't need a lawsuit coming right up to explain that to the business, particularly the small business. I'd like to see carve-outs and you get 30 days. If you get 30 days to the bill sponsor, if you get 30 days to fix the problem and the problem gets fixed, then should there be any further liability? If they've fixed the problem, if they have repaired and remedied, or should we have some lawsuit that says, oh, we're going to sue you for a couple $1 million? And oh, by the way, we'll take a settlement. We'll take a 1% settlement. That'd be $20 million if you really want this to go away. That's the shakedown that this letter talks about. Anyway, I'm going to skip this page here. I'm going to the last page in the article, ma'am. And I've actually, to the bill sponsor, just so you know, I've skipped 2 pages, 2 solid pages. And I could keep going, but I won't. I had a deference to my colleague in this conversation. Okay, and this is important. People with disabilities have just as much a need to patronize small business as anyone else, and I agree with that. But people who blame merely for noticing that the business they were sued were out of compliance with ADA, and I think we need to be in compliance. We need to work towards compliance. But lawsuits and litigation isn't or shouldn't be the primary pathway. That's why I have an issue with, in this case, I believe it's line 17 through 20 in L006, because I don't know if it closes this door. I don't know if it closes this litigious door. It's going to hurt small business. And small business doesn't need to be kicked around at this time, any more than they already have been. So I'm not even going to make these final points. I'm just going to close with I still have reservations and concerns. I do appreciate the part of it that says this to a working group, but we absolutely have to create conditions that allow for compliance and do not allow an open door for litigation. We don't need lawsuits a go-go. We don't. So with that, Madam Chair and esteemed colleagues, I hope that common sense will prevail. And I really appreciate the intent of the bill, but I still have some reservations with respect to the elements of the bill that could harm Colorado and Colorado business in a way that just enriches lawyers who are out there just trying to line their pockets with money and really don't really care about the underlying premise as long as they can turn cases and line their pockets with money. Thank you.
Representative DeGraff.
Thank you, Madam Chair. I still do have some questions. I did get some answer based on looking at 5.6 as qualified individual with a disability or individual with disability has the same meaning as set forth in the Federal Americans with Disabilities Act of 1990, 42 U.S.C. 12131, and its related amendments and its implementing regulations. I don't think we need to talk about race. That's the next one. Qualified individual with an immunity with a disability. The term qualified individual with a disability means an individual with a disability who, with or without reasonable modifications to rules, policies, or practices, the removal of architecture, communication, or transportation barriers, or the provision of auxiliary aids and services, meets the essential eligibility requirements for the receipt of services or the participation in programs or activities provided by a public entity. And so we're talking about public accommodations here. So with or without reasonable modifications to rules, policies, or practices, the removal of architecture, communication, or transportation barriers, or provision of auxiliary aids and services meets the essential eligibility requirements for the receipt of services or the participation in the program provided by a public entity. So if you had a difficult time listening to that as I did reading it, I mean, that's just part of what our businesses are expected to deal with. Now, I think most businesses in general, where they can, want to comply with this. But these are modification to rules, policies, or practices. So we have rules, policies, or practices, and then you have removal of architecture. That's going to be a occupancy issue, a zoning issue, a code issue, communication, transportation barriers, all code, zoning, provision of auxiliary aids and services. So I'm 100% in favor of making the public more accessible to persons with disabilities, and in this case, by the bill sponsor, those qualified individuals with a disability. So by the wording, I think that takes out some of my concern about being overly broad, but this still comes down to a zoning issue, a zoning or a code enforcement issue. And now it seems like instead of, like if somebody has an issue with the compliance with code, that they would file a complaint against the they would file a complaint with the code and zoning departments and then they would go out and make sure that they are in compliance. Now we're looking at bypassing that and going straight into litigation. So I'm still very concerned about this. I'm very concerned about this in general. Again, I like the idea. I like the idea of making public more accessible, but these rules are first and foremost codified in code, in statute, in policies, and we need to honor that, and we need to go through that process as opposed to the litigation process. So now, as my colleague mentioned, that this has been in for 33 years, and there are still a lot of issues to be discussed with this, I would like to move L010 to L006 and ask that it be displayed. And this is just because this has the...
One moment, Representative DeGraff. You moved Amendment L10 and asked for it to be displayed. Let me make sure that's up first before we continue.
L010 to L006.
Thank you. Please proceed with Amendment L10.
Thank you, Madam Chair. This is not an issue of whether this is a serious matter. This is just a standard petition clause, just because there are issues with this. I do understand that this is it's a matter of health and possibly safety, but this is a 33-year-old issue, and there are issues with this bill. So I would ask that we would go to a petition clause for the proper use of the clause in this case, since it is not immediate. Although I do respect some level of the safety clause in this case. I think the petition clause is still more accurate, and I'd ask for an aye vote.
Representative Ortiz.
Thank you, Madam Chair. And although I do appreciate my colleagues bringing forward petition clauses, because on 75 to 90% of them I agree with them, we're talking about the basic access of individuals to participate and live in this world. It is a safety issue. We need to start, I think, and it's not purposeful or malicious ableism, so let me start by saying that very clearly, but we need to start equating basic access to basic human rights to our safety and well-being, immediate safety and well-being. So in this case, I'm going to ask for a no vote.
Any further discussion on Amendment L10? Seeing none, the question before us is the adoption of Amendment L10 to Amendment L6. All those in favor say aye. All those opposed, no? No! Amendment L10 is failed. To Amendment L6. Seeing no further discussion on Amendment L6 to House Bill 1032, all those in favor say aye. Aye. All those opposed, no? Amendment L6 is adopted. To the committee report. Seeing any further discussion on the committee report? Seeing none, the question before us is the adoption of the committee report to House Bill 1032. All those in favor say aye. Aye. All those opposed, no. Committee report is adopted. To the bill, House Bill 1032. Any further discussion on House Bill 1032? Representative DeGraff.
Well, that reads like an onion. You go into the amendment, and then the committee report, and then now it becomes the bill. Again, I like the idea of this. I think the access is ensuring access and working with businesses is fantastic. I think there is, in general, a large desire to comply. I would like to. I think this is leaning too far in the direction of litigation, and it creates a fuzzy area here with code compliance and statute compliance. So, I would prefer this was went back for some further work. Although I know the sponsor has worked extensively on this. I would like to make sure that this was tightened up a little bit more before we turn it loose on our population.
Any further discussion? Representative Holtorf.
Thank you, Madam Chair. And I still rise with concerns. And I told my constituent I would read this letter. And I'm a man of my word. So it must be done. Because your word is your bond. So I'm going to read this letter. I'm not going to say his name. But this is from a small business owner in my district in Alt, Colorado. Real people in real places in rural Colorado. Because I want you to understand something, folks. A small business operates on very small margins and typically has less than $1 million or $1 million or less of equity in their business. They might have $1 million or less of assets and equity. And that's a small business. So when you get one of these lawsuits, it could be the end of the business. That's the point I want to get in everybody's head. These small businesses do not have a lot of capacity for civil action and lawsuit. They're having a hard enough time just getting employees to show up to work and making payroll and keeping inventory and running a business, let alone have to deal with some jackwagon lawyer who comes in with a big old letter saying, we're coming after you. That's how we feel about it where I'm from. So here we go. As a small business owner in your district, that's House District 63, I am strongly opposed to House Bill 23-1032, proposing detrimental changes to Colorado's laws against discriminating against those with disabilities. Charges of discrimination against a small business can cost anywhere from $250,000 to $500,000. Most of the time, businesses are forced to shut down due to exorbitant costs associated with these charges. Let that sink in for a minute. House Bill 23-1032 would make the process of shutting doors due to a discrimination charge far quicker, putting small businesses at a huge disadvantage. Small business owners reserve the right to rectify the conditions before being ordered to the courts, paying burdensome fees and/or fines. I urge you to oppose House Bill 23-1032 and allow small businesses, where I'm from, but businesses here in the chamber, the ability to charge, to fix the changes and charges, and save them from closing their doors. Sincerely, my constituent from Alt, Colorado, and a small business owner. This is just one guy. There are thousands of small businesses that are saying the same thing. I hope that we don't become like California. I hope that we don't have a bunch of litigious lawyers out there licking their chops, rubbing their hands together, and saying, boy, it's going to be payday in Colorado with this type of legislation. I hope that these type of lawyers aren't behind this legislation.
Representative Holtorf.
Yes, ma'am.
Can we not impugn motives of folks in our communities, please?
I'm not imputing anybody. I'm just hoping. I'm hoping. It's hope. Hope for Colorado, ma'am. I didn't specifically say anything or anybody. I'm talking about hope and change. Will it be good change? And will the hope of my small businesses be met with good change, or will it be bad change? And small businesses continue to get kicked and stomped and basically more things to deal with that they can't deal with because they've already dealing with everything else. Now, ladies, this is a legitimate plea and a legitimate concern. I don't come down here lightly on this one. As a champion for small business, standing up for small business, which is the heart and foundation of our economy, do we lift them up or do we push them down? Do we create conditions for remedy, or do we just create more liability? Those are the questions that you have to ask yourself as we move forward on this bill and with the changes in the form of L006, Madam Chair. Thank you for your attention.
Representative DeGraff.
Thank you, Madam Chair. And I do have also have emails from constituents on both sides, because this is an important issue to a lot of people. So gaining access, I think, is for everybody in our community is important for everybody, I think, in this room, no matter what side of the aisle that you're on. But there's a lot of questions that have been raised today, and I would like to see them. I think they deserve further hearing. I think the constituents that we have need to be able to look at this strike below, because this does change quite a lot. And so therefore, I would like to make a motion to refer it back to committee.
Motion has been made to refer the bill
I guess that's Judiciary Committee.
back to Judiciary Committee. Representative Ortiz.
Members, I guess the cliche of no good deed goes unpunished is exactly true. Because I have negotiated in good faith and stripped off the more contentious aspects of this bill and moved them to a task force.
Rep Ortiz.
Yes, Madam Chair.
Please proceed.
Yes. All that is left is clarifying what already exists in statute. And we debated that at length around administrative exhaustion. This has been debated for hours. So I would urge a no vote on referring it back to committee. Yes, we did a strike below, but that was stripping the more contentious portions, not making it new, and we're not adding anything new here. We are simply clarifying what already exists in that we don't and should not have to go through administrative exhaustion. I urge a no vote.
Representative DeGraff.
Thank you, Madam Chair. I do appreciate that clarification. This is not to impugn or challenge. I just think in the discussion that there have been more questions, and there are still some remaining questions about the not the intent, certainly not the intent of this bill, not the desire of everybody to make sure that everybody is included, but to make sure that we have the wording correct. I do appreciate my colleague on the clarifying on the strike below that there is absolutely nothing new here, and so that makes it easier. But I do think there are some. I think there are still some questions that need to be addressed a little bit more carefully in judiciary on how this process proceeds. So certainly not the intent, not a challenge on the intent, not entire on the character. I think this is an important bill, and yeah, I just think it's an important bill, and I think it's one that we should make sure that we have fully I's dotted, T's crossed, and everything before we codify it into law, because I fully anticipate it will be. So that's my only issue. Thank you.
Seeing no further discussion, the question before us is the motion to send House Bill 1032 back to the Committee on Judiciary. All those in favor say aye. Aye. All those opposed say no. No. That motion fails. Back to the bill. Seeing no further discussion on House Bill 1032, Representative Ortiz.
Thank you, members, and I do appreciate the robust debate that has been going on this bill. We also had a robust debate in judiciary. There's been a lot of things that have been said at the well, folks, and I want to be very, very clear. The main sponsor of this bill has and will continue to support small businesses. Ran 2 SALT parity bills that got millions of dollars in tax cuts for small businesses, right? But these freedoms that we enjoy, the promises in the Constitution, should apply equally to everyone equitably. I raised my right hand and swore an oath to this Constitution, only to come home to a state and to a nation that left and right blocks me from participating in the freedoms that I fought for. Malicious or not, it is happening. And it's not like ADA was passed just last year, folks. We're talking about a law that is 33 years old. The original version of this bill that I brought forward sought to change what has been okay for 33 years on trying to enforce our basic civil rights. In good faith, I stripped out the more contentious portions of that bill, even though I know there needed tools to finally secure my basic civil rights, and moved them over to a bipartisan task force. And in this bill, all I did was clarify already existing language around administrative exhaustion. Nothing new. And I'm getting accused of not supporting small businesses. I'm getting accused of, or my community is getting accused of being extortionist.
Representative Ortiz, let's stick to the bill.
This is to the bill and what was said.
To the bill.
Correct. All we are trying to do here is clarify confusion among judges based on current existing statute around administrative exhaustion. I have earned the right to have basic access to participate in this world. I swore an oath. I have a basic right. And even that statement is a little bit ableist, because whether you've served in this military or not, when you live with a disability, you deserve the right to participate the same opportunities that any able-bodied leg walker has in this world. That is all this packet of bills is trying to do. This one in particular only clarifies around exhaustion. I don't know how many times I have to get up here and ask for my basic civil rights here, folks, or be accused of not supporting small businesses. I have supported them, and they know it. But when you live and benefit from one of the greatest nations in the world, it comes with responsibilities. You don't get to discriminate against 20% of people living in your state. You don't. And if we have to go to court to do that, sure, I'm getting accused of being a serial litigant. Great. What I am serial about is securing my basic rights, and that is all this is trying to do. That is all my work is centered around. I urge an aye vote.
Representative DeGraff.
Thank you, Madam Chair. This is awkward, and I do appreciate my my colleague, and I do agree with him on, I think, pretty much everything. I do agree that he earned the right, but I also agree that he did not need to earn that right, and that right needs to be extended. I thought we made it fairly clear that no one was accusing our colleague of being a serial litigant. Nobody accused. We made what I heard was the efforts to would be to 100% stand behind the intent of this bill, that everybody in question did not have any issue whatsoever with the purpose of this bill or with the need of the bill. There's remaining some questions about whether this is even on the exhaustion issue. I do agree with the example that was given of requiring a 2-year time frame before it could even move forward. That's wholly it can't be sustained. That's not feasible. It's not reasonable to ask somebody to put up with deal with a we have a court process that's supposed to be expedited. But what we have to do is make sure that, and we have questions, that's all. We have questions whether this is the right way to do what I would say is the right thing. And we want to make sure that everybody has the proper access to the max extent possible, and that is as codified per the bill, what is now the bill, in statute with the ADA. I'm sorry that my colleague felt that we were impugning his motives. I'm sorry my colleague felt that we were calling him a serial litigant. I don't recall anybody calling him a serial litigant. But the fact is that when we put something into the black and white of the CRS and put it into law, that it be correct, and that when we take the people away that have to explain it, that it stands alone, and that it does not have any unintended consequences. That's all. I think this is I think ensuring that whether an injury was sustained in war or in the service of country or not, I don't think that's, I don't want to say it's immaterial, it's certainly material, but I don't think I think we want to make sure that all of our citizens are afforded the proper procedures. And we're not trying to avoid that, we're not trying to evade that, we're certainly not accusing our colleague of attacking small business. I think that's probably the furthest thing from our mind. It's just making sure what's in the law. Now, we're going to vote on this, and if you're comfortable with the law, as it's written, then it will carry. If you're not 100% comfortable with the way it's written, then you'll vote no, and it will probably not carry. But it's not a matter of judging. It's not a matter of judging whether this is worthy or not. It's a matter of whether we discuss it further, make sure that there's no other language, make sure that this can't be used inappropriately. Because that is the nature of the laws that are created here, is that they are quite often used inappropriately. Every single law, well, I'd say most every law, the intention is that they're not used inappropriately, but yet they are. And that's why we have a term called lawfare. Nobody's accusing our colleague of that. We're just trying to avoid that, because if that happens, that causes more harm than a delay. I don't think we need to, this is not a postpone indefinitely, this is not a shelf, this is do we need further discussion? Some feel it does, some feel it doesn't. I think it does, but I think the bill is important. I think the intent is, I'm sure the intent is honorable. I don't have any questions about that. So I'm sorry that I do understand my colleague being upset about it and feeling he was impugned, but if we conveyed that, I am sorry, but that was not the intent. So I would still hope that we send this back to committee to discuss it, to make sure it's all good, and then we bring it forward, and then we vote on something that we're all confident in.
Thank you. Seeing no further discussion on House Bill 1032, the question before us is the passage of House Bill 1032 as amended. All those in favor say aye. Aye. All those opposed, no. No. House Bill 1032 is passed as amended. Mr. Schiebel, please read the title of House Bill 1056.
House Bill 1056 by Representative Hamrick, concerning modernizing record keeping by the state archives.
Representative Hamrick.
Thank you, Madam Chair. It's a pleasure to serve with you.
It's also an honor to serve with you. Representative Hamrick.
Thank you, Madam Chair. I also want to say that it's an absolute pleasure to serve with my esteemed, dedicated, and patient colleague from Arapahoe County. Madam Chair, I move House Bill 1056.
Great. To the bill.
I'm here today to present the long-awaited Efficiency at the Archives bill. As a high school history and government teacher of 32 years, the Archives holds a special place in my heart, as well as a critical space in our government. The Colorado State Archives exist to ensure the preservation of the state's permanent legal records and information to promote their use by the citizens of Colorado. The archives are the legal repository for selected historical and contemporary records and information generated by the state and local governments in Colorado. Colorado State Archives has long needed to modernize the practice of preserving and producing state records and publications, and this bill gives them the opportunity. This bill increases government transparency, accountability, and accessibility with no fiscal note, and it passed through the State and Veterans Affairs Committee unanimously. I ask for an aye vote on House Bill 23-1056.
Any further discussion on House Bill 1056? Representative Winter.
And maybe you could answer this because I was reading over this. Thank you, Madam Chair. The question I have is so like when they're talking about visual recordings and stuff, would that be anything that like a legislator would have in email, or like Zoom meeting recordings? Would that fall in any of this if they wanted to keep records for, say, like a certain committee or a, you know, like say agriculture committee? We heard a bill that they considered groundbreaking. Would they ask for like any Zoom meetings that may be recorded or any emails that we may have to go in with that? That was just a quick question I had for you.
Representative Hamrick.
That's a very great question, and I will get back to you that. I'll ask the archives about that. It's a very good question.
Thank you, ma'am.
Any further discussion on House Bill 1056? Your first warning, sir, you will need to be in the well to be recognized. Representative Weinberg.
Yes, Madam Chair. Thank you, Madam Chair. Sorry, Madam Chair. It's an honor to serve with you.
Honor to serve with you.
I would like to move an amendment L002 and ask that it be displayed.
You would like to. Are you sure you want to? I'm joking with you. But it is true. So amendment L2 has been properly moved. It
Thank
is
you,
now
Madam Chair.
before us. Please continue, Representative Weinberg.
Thank you, Madam Chair. This is just a technical amendment. Looking through in this bill, I do IT for a living, and I don't understand how you could scan in a video. So I would ask that you would add or stored, just a technical amendment. And I urge an aye vote.
Any further discussion on Amendment L2? Representative Hamrick?
This bill was stakeholdered pretty much all session, and so I urge a no vote.
Any further discussion on Amendment L2? Seeing none, the question before us is the adoption of Amendment L2 to House Bill 1056. All those in favor say aye. Aye. All those opposed, no. No. Amendment L2 fails. Any further discussion on House Bill 1056? Seeing none, the question before us is the adoption of House Bill 1056. All those in favor say aye. All those opposed, no. House Bill 1056 is passed. Madam Majority Leader.
Thank you, Madam Chair. I move the committee rise and report.
After the chorus, you've heard the motion, members. The committee will rise and report. Okay, we don't do it again?
The House will come back to order. Mr. Schiebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report it has under consideration the following attached bills, being the second reading thereof and making the following recommendations thereon. House Bill 1026 is amended, 1032 is amended, 1056, and 1251 passed on second reading in order and engrossed and placed on the calendar for third reading and final passage.
Representative Gonzalez Gutierrez. Thank you. Members, you've heard the motion. There are amendments at the desk. Mr. Schiebel, please read the Luck Amendment to the Committee of the Whole report.
Representative Luck moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Luck Amendment, L8 to House Bill 1026, to show that said amendment passed and that House Bill 1026 is amended passed.
Representative Luck.
Thank you, Madam Speaker. So I move the Luck Amendment to the Committee of the Whole and ask that it be displayed.
It is properly displayed. Please proceed.
Thank you, Madam Speaker. So in the bill, there's definitions for grandparent and great-grandparent. And those definitions include folks who are related by blood, by adoption, or by marriage. Under the blood category, there's a qualifier. It says in whole or by half. Now, in other parts of family law, there is similar language, but those times, so at least some of them, they reference siblings, which makes sense. You can have a half sibling, right? You can share a father but not a mother. And so you can have half. But no one has been able to clearly explain to me how you have a grandparent in half, like how you only have half of the grandparent. And again, as I've done research into this, seemingly the origins of this particular phrase as attendant to parents and grandparents is not something that I think many in this body would honor. And so I am asking for reconsideration of this amendment to just strike in whole or by half, leaving it as blood, adoption, or marriage, and so that we can remove what is at minimum confusing language, but at maximum potentially detrimental to the kind of culture that we would be desiring to create. I ask for an aye vote.
Representative English.
Thank you, Madam Speaker. I ask for a no vote.
Seeing no further discussion, the question before us is the adoption of the Luck Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Please close the machine. With 23 aye, 40 no, and 2 excused, the Luck Amendment is lost. Mr. Schiebel, please read the Soper Amendment to the Committee of the Whole report.
Representative Soper moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Soper Amendment, L8 to House Bill 1032, to show that said amendment passed and that House Bill 1032 is amended passed.
Representative Soper.
Thank you, Madam Speaker. I move the Soper Amendment to the Committee of the Whole report and ask that it be properly displayed.
It is displayed. Please proceed.
Thank you, Madam Speaker. So we had a pretty lengthy debate about this, and it wasn't that long ago, so I won't necessarily rehash every word in that debate. But if you remember, there's the provision that the business entity must comply with their ADA failure, and then the court then must award either actual damages or statutory damages, one or the other. This changes it to where the court may award actual damages or statutory damages. It puts the onus back with the court to make that determination, and I'd ask for a yes vote. Thank you.
Representative Ortiz.
Thank you, members, and I appreciate all the members for the robust debate. I am asking for a continued no on this amendment.
Seeing no further discussion, the question before us is the adoption of the Soper Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Please close the machine. With 19 aye, 44 no, and 2 excused, the Soper amendment is lost. Mr. Schiebel, please read the Weinberg amendment to the Committee of the Whole report.
Representative Weinberg moved to amend the report of the Committee of the Whole to reverse the action taken by the committee not adopting the following Weinberg Amendment L2 to House Bill 1056 to show that said amendment passed and that House Bill 1056 is amended passed.
Representative Weinberg.
Thank you, Madam Speaker. After speaking with the bill sponsor, she is going to take it into consideration with her stakeholders. I will withdraw this amendment.
Thank you, Representative Weinberg. Amendment is withdrawn. Members, the motion before us is the adoption of the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Please close the machine. With 46 aye, 19 no, and 0 excused, the report of the Committee of the Whole is adopted. Announcements and introductions, members. Representative McLaughlin.
Thank you, Madam Speaker. Education will meet 5 minutes after adjournment today. Thank you.
Madam Majority Leader.
Thank you, Madam Speaker. I move to lay over the balance of the calendar until later today.
Seeing no objection, the balance of the calendar will be laid over until later today. Madam Majority Leader.
Thank you, Madam Speaker. And just to keep all of you up to date here, that we're going to return to the floor this afternoon after committees wrap up so we can finish our day of work. So I wanted all of you to be aware of that. So stay close to your phones and just follow committees. After that, Madam Speaker, I move that the House stand in recess until later today.
Seeing no objection, the House will stand in recess until later today.